It is filled with the rarest of treasures, wisdom, experience, curiosity, and the spirit of contribution.
We are here to celebrate 50 golden years of professional greatness. Let's look forward to the future, but most importantly, let's enjoy the present.
On behalf of all India Federation of Tax Practitioners, celebrating its glorious Golden Jubilee, in association with Karnataka State Chartered Accountant Association and the Bengaluru branch of SIRC of ICAI, it is my honor to welcome you all to the 28th National Convention 2025, a two-day festival of intellect, insights, inspiration, and of course, impeccable professionalism. Ladies and gentlemen, give a huge round of applause because our guests, all the
These 2 days stand on a powerful theme, the 3 E's: ethics, education, and excellence. Ethics keep us grounded, education keeps us evolving, excellence keeps us moving forward.
the front seat. I request all the individuals out there to please come and grab the seats in the front. I request all of you
Institution.
महागणपतिं मनसा स्मरामि 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 वसिष्ठवामदेवादिवन्दितं महादेवसुतं गुरुगुहनुतं महादेवसुतं गुरुगुहनुतं महादेवसुतं गुरुगुहनुतं मारकोटि प्रकाशं शान्तं महादेवसुतं गुरुगुहनुतं मारकोटि प्रकाशं शान्तं महाकाव्यनाटकादिप्रियम् महाकाव्यनाटकादिप्रियं मूषिकवाहनमोदकप्रियं महागणपतिं मनसा स्मरामि वसिष्ठवामदेवादिवन्दितं
Thank you so much, Aditya, for that serene start. Now, to honor our esteemed guest, may I invite Convention Chairman CAFR Singhvi to present a book to our chief guest, Honorable Mr. Justice Ujjal Boyan, Judge, Supreme Court of Karnataka, Supreme Court of India.
Now, I invite Mr. Sandeep Chunnilal Shah to present a book to our guest of honor, Honorable Mr. Justice Vibhu Bhakru, Chief Justice, High Court of Karnataka.
Ladies and gentlemen, please give them a huge round of applause. May I now request Advocate Sameer S. Jani, National President of All India Federation of Tax Practitioners, a leader who embodies grace, vision, and an unwavering commitment to his profession, to kindly deliver the welcome address.
Good morning. Good morning. Good morning, everybody. After having a nice breakfast, we are all assembled in time. Few minutes late. It's the indication of beginning. is with great pride and profound joy that I extend my warm greetings to all distinguished guests, respected past presidents, eminent professionals, and esteemed members of All India Federation of Tax Practitioners who have gathered from across the country on this 28th National Convention at Bangalore. In spite of all odds, we know there were many cancellations on account of cancellation of flights, reschedulements. The occasion is truly momentous as the Golden Jubilee celebration started at Calcutta with the gold curtain raiser with the able hands of Justice, none other than Honorable Justice Ujjwal Bhuyan, Judge Supreme Court of India, whose presence not only honors us, but also inspires the entire tax fraternity. His deep understanding of constitutional and tax jurisprudence has enriched the legal landscape of our nation, and we are privileged to have him us on this significant day. The National Convention stands as a confluence of knowledge, experience, and vision. While delegates representing every region of India, the deliberation over the next 2 days will span a wide spectrum of direct and indirect taxes, addressing emerging challenges, contemporary policy issues, and the dynamic reforms shaping our professional environment. In these times of rapid economic, legislative transformation, such platforms are vital for fostering clarity, collaboration, and professionalism. As we move forward, it is important to acknowledge the foundational role played by our past presidents, senior leaders, and mentors who have nurtured the Federation over the past decades. Their guidance continue to strengthen our resolve and enrich our collective journey. I am grateful for the presence of their presence today, which reinforces the unity and continuity and define AIFTP. This year, we have C.A. Venkatramani as our national president. After a very long time, we have a chartered accountant as our national president. Thanks to CAFR Singhvi ji, who motivated Venkatramani ji to take it over. I, as an immediate past president, assure national president, incoming national president, that I will stand with you like a wall for the entire year. I wish you very good luck, and let me remind you, Venkatramani ji, that Justice Ujjwal Bhuyan administered the oath to me, and my year has been successful, that you are witness to. Now he is like a Ganapati. Rest assured, your year is also successful. I thank everybody for joining. Thank you very much.
Thank you so much, sir, for those warm words. We now invite Convention Co-Chairman, C.A. Padam Chand Kincha, a respected voice of clarity and distinguished leadership, to offer his opening remarks.
Honorable Justice Ujjwal Bhuyan, Judge Supreme Court of India, Honorable Justice Zhu Bhakru, Chief Justice High Court of Karnataka, dignitaries on the dais, dignitaries off the dais, distinguished participants here. We are at a sacred confluence today of mind, hearts, and aspirations. 13th December 1577 was the day when Sir Paul Drake set out from the port Plymouth for the purpose of finding out new horizons, new destinations, exploring the world. he showed and exhibited characteristics of some efforts beyond normal. 14th December, that is tomorrow, marks the anniversary of Ronald Amundsen's journey when he reached South Pole first. Again, an absolute incident of going beyond normal human endeavors. So this is the destiny, this is the cosmic alignment, in my opinion, today, that we are assembled on the very same 13th and 14th of December, where we are going to therefore join together to explore these possibilities, cross frontiers of knowledge, because we are at a very inflection point, very significant point of inflection in the course of our human endeavors, where we have law, we have technology, we have business dynamics, we have jurisprudence, all joining together. The churning is so high in these fields concerned that it becomes extremely important for us that we are prepared. We are prepared to meet them, we are prepared to address them, we are prepared to master them. And therefore, it's a confluence today that we have chosen these two good days. Cosmic alignment is absolutely fine. And we have some wonderful people with us to guide us in these transformative times, that the people who are guiding us and the participants here can make this as a beacon of transformative times to come. All India Federation of Tax Practitioners is a very unique organization. It has spread across the country, length and breadth of the country. That's one part. Second, it has a combination of judges, chartered accountants, practitioners, lawyers, academicians, people from the revenue. So it's a very unique organization that has a multitude of people from various angles coming in together for the purpose of sharing their knowledge concern. And it is built on a very strong foundation of ethics, education, and excellence. These are not just mere ornaments. These are the very oxygen that is required by us for meeting the challenges in these times concerned. These are the very foundational aspects that will help us in continuous and relentless learning for us to achieve multidisciplinary strength in terms of addressing various problems today. And it is in addressing these problems that we have chosen the topics over the 2 days concerned, where we have thought leaders, where we have people who have been very wonderful in business, who have been carrying on professional to very great heights, senior advocates, junior professionals, tax practitioners, all coming together for the purpose of sharing their knowledge on a range of diverse topics concerned, beginning from the very mundane GST to high-level concepts of where India is going to be there tomorrow in 2047. The whole purpose of this conference, therefore, is to have some sort of a T-type of a development. Perfect harmony of what? Of breadth and depth. Perfect harmony such that tomorrow, when we're dealing with problems concerned, we don't have problems that are in silos concerned. We don't have something labels of only GST. We don't have labels only with income tax. We have a combination where these are interdisciplinary, hybrid type of puzzles that requires competent skill from our side for the purpose of addressing them. And it is this conference of this nature concerned, when we start and appreciate that technology helps us, absolutely fine. It gives us speed, it gives us accuracy, it gives us scale. But it's only when this speed, accuracy, and scale is combined with education, with ethics, and with excellence that we're able to have a compassionate and a well-rounded deliverance of justice or a solution to people concerned. It's therefore very appropriate that these are the times when we reaffirm the faith on the aspect that education is going to be the fiber for all of us. It's going to be the basic fiber for all of us, where we have the aspect of strength being imparted by ethics and the final rope coming in through, and which can carry us forward through the aspect of excellence. This is the place where today, therefore, this conference will have people who have set standards in the higher echelons of work, who are erudite, who have had absolute demonstration of highest levels of skills in terms of delivering justice today, giving us the words of inspiration, getting us sparks for us to therefore ignite our minds concerned, and we believe that their ideas will resonate through the entire 2 days of conference concerned. Therefore, honorable gentlemen here, present ladies and gentlemen here, let us therefore devote these 2 days to a wonderful days of learning, where all of us from multitude disciplinary backgrounds are able to join, are able to share, are able to enrich all of us concerned, and therefore To also the leaders concerned tomorrow who are going to assume office, all the best for carrying forward this legacy in the all times to come in future. Thank you all.
Thank you so much, sir. To mark the beginning of this August convention, we shall now invite our honorable chief guest, guest of honor, dignitaries on the dais for lighting the ceremonial lamp. The lamp represents Vidya, the light of knowledge. Knowledge is the only wealth that grows when shared, and today it is shared by the finest minds of our fraternity. As the flame rises, may it illuminate our collective commitment to ethics, education, and excellence. Ladies and gentlemen, give these gentlemen a huge round of applause.
We now take the honor of inviting Convention Chairman CAFR Singhvi, a visionary whose dedication has shaped every aspect of this convention, to address the gathering.
Hello. Hello. Is this better than the previous speaker's mic? Good morning to all the ladies and gentlemen. It's a very unusual situation for me that has arisen in 20 years, thanks to Venkat. I pulled him into my firm, and then when he becomes the president here, he pulls me back to the CA fraternity and legal luminaries after 20 years. So I'm attending a conference after 20 years, and I cannot express how elated I am, how the kind of gratitude I have for all of you to call me back to my own house where I started. Thank you very much. Sir, esteemed Chief Guest, Honorable Justice Ujjwal Bhuyan, it's a pleasure meeting you again, sir, in a short period. Like I said the other day, that was the first time I sat next to a Justice of Supreme Court, and today I have another opportunity. Thank you very much. Guest of honor, Honorable Chief Justice of Karnataka High Court, Sri Vibhu Bakru. Welcome, sir. He was smarter than me. He left the profession after 7 months of practice. I left after 25 years of practice. Our beloved President Sameer Jani Saab, I must say, the kind of personality he is, the first time I met him in Calcutta, I fell in love with you, sir, with the kind of youth abilities, youth mind that you have. And congratulations on having led this organization in a great manner last year. one of the pride thing of Bangalore is having Padam Kincha from Bangalore, my co-convener of this conference, who's really made a name for chartered accountants of Bangalore. And let me tell you, Padam and I are more like the jewels. The whole convention has been designed and done by Venkat and his team. So Venkat, I will not welcome you. You have always been literally a part of me. I feel very proud that you have not only distinguished yourself as a better GST consultant than I was, but leading this organization, I'm sure with the kind of abilities that you have, this federation would go much faster and much higher. Venkat had told me 15 minutes. He normally tells certain things and does certain things a different way. I have to be prepared. He gave me 15 minutes, and now in the printout I see 5 minutes, and we're already late by 15 minutes. So I would not take much of time, but just to say that I will repeat my advice to all of you. Padam has already said we have to keep transforming. I used to always say at regular institute seminar as a speaker that don't be tax advisors, be business advisors. Tax is a very small element of business. If you do business planning, business strategy for your clients, tax planning will automatically come. Today, with my own experience and practice and in industry, I can tell you today very, very confidently that you are competent people for tax matters, but you are more competent to lead the business in the country. The kind of financial requirement in industry, the ingenuity that is required, the science that is required to manage finance, let me tell you, ladies and gentlemen, you are the most fit people on that side. And the legal situation in the country, unfortunately, we are highly litigant nation. And on top of it, our judiciary is so preoccupied and with less of resources that country can afford to give them, we have pendency of legal cases for a long time. I would urge today in front of both the Justice and Chief Justice that we need to really transform the legal system, that we come out of the micro litigation and be more at the macro litigation. Like in business, I have found that most of the issues that as chartered accountants we litigate are smaller issues. We fragment businesses to save taxes, but in actual real practice, we make the business smaller. We reduce our profits. Our country has grown from 0.8 trillion in 2005 when I quit CA practice. And today we are at 4 trillion, almost 4 trillion. Whereas the global GDP has grown from 56 trillion to 112. So it's 2 times versus 5 times. But have our whole way of working at the country level really changed? Yes, it has changed, but is it enough? To me, it's not, because when I look at next 20 years, the international GDP is likely to grow again twice, 110 to 250 trillion. But Indian economy is going to grow from current 4 trillion to 30 trillion by 2047. That's almost 8 to 10 times. The kind of technologies that are coming in, the kind of transformation happening in the digital world coming in. Imagine the economy growing 10 times. What happens to the businesses, industries? They grow 20, 30, 40 times. I can tell you my own industry, we have grown more than 34,000 times in last 25 years. And believe me, ladies and gentlemen, that we will grow much faster. What we did in last 30 years, we'll do it in 10 years. Is the profession ready for this? Are you ready for this? It's changed a total mental shift. It requires a change in attitude. It requires new skills. It requires you to use technology but not get dependent on technology. You still need to learn the fundamentals. You still need to know how to interpret, how to go through the jurisprudence, thoughts of law, which again, I can tell you that with my experience of employing people, chartered accountants, it's actually coming down. So imagine when the AI come in, the blockchain comes in, what happens to your profession? In fact, if you look at income tax law changes and the kind of digitalization that is coming in, most of the routine jobs are going to go away. So I would like you to deliberate not only for the immediate future or medium, but look at longer time. 2047 is going to be 100 years. Our country is totally working on 2047. Have a deliberation of where the profession would be by 2047. Imagine the company is going multinational from India. We were inviting multinational to India. Today we are going multinational. Most of our companies are going to go multinationals because we have the strength of people. We have the strength of young generation, which most countries lack. They are inviting us to be in their countries. Where would your practice be when companies go multinationals? You should not remain small. You have to grow bigger, larger, faster than the business growth. If I look at the CA Institute statistics, today we have less than 500 firms with 10 partners and more. How are we going to manage this? Even the existing clients of yours will go 20, 30 times, and they'll find your firm is small. I would urge not only all of you, but even the institute, that please look at it. How do we become more, have an advisory role in a most ethical manner, not just in India, but across the globe? Our Indian engineers have gone across. How many chartered accountants have done that? It's not just because of us, but it is also how the institute takes it, how the government takes it. So these are the thoughts that I leave it to you for deliberation. And before I conclude, I must here acknowledge the presence of Mr. P.C. Joshi, the founder secretary of this federation. Sir, it's been a fortunate for me to be with you for 20 years in a row, being on the dais with you for so many years. And when I met you in Calcutta, I knew that you continue to be my role model. It was earlier for profession. Now it is how to be healthy at 91. Please emulate him, ladies and gentlemen, how to be healthy, strong, and still with all the intelligence and mind that he had. I must also acknowledge Mr. Shivram, who's been the backbone of this federation from the behind. Always there, presidents come and go, Shivram remains. And I would not be standing here, ladies and gentlemen, for one person here who has been supporting me, the heavyweight, Mr. Devraj, my partner in SDU firm as well as in Sansera. So thank you, ladies and gentlemen. Have a good deliberation. Thank you.
Thank you so much, sir, for those blissful words. We now hand over the further proceedings to Advocate Sameer S. Jani, National President of All India Federation of Tax Practitioners, for a special presentation.
Friends, it's time to hand over and give the torch to my most efficient and next man, Deputy Chairman. But before that, sir, give me few minutes. I would be announcing some of the awards. In fact, there are many awards, but we'll be doing that program. But with your auspicious hands, we'll be delivering token 5 awards. I would request for the base zone, request Mr. Pandey, Mr. Anand Kumar Pandey. Is he here? Please be fast. If he is here, जल्दी आ जाइए, क्योंकि फिर सर निकल जाने वाले हैं, तो आपको उनके हाथ से नहीं मिलेगा. खड़े रहो ना, यहाँ रहो. हाँ. Base zone, North Zone, Mr. Anand Pandey and Mr. O.P. Shukla, the Vice President. आइए अरविंद जी. Base zone. Sir, क्या थे? They were more active and vibrant for the whole year, sir. Now I would request Best Conference Award goes to Western Zone Baroda National Tax Conference. I would request Mr. Sachin Gandhi, the chairman of the West Zone, to be here. And Mr. Akshay Modi, who is the incoming chairman. Singhvi sir would be more interested in this. Now the next award is for the outstanding contribution for the development of Federation Professional, Mr. Tushar Apani. In absentia, I would request Mr. Bhavya Popat to take the award and deliver it to him. The fourth zone, best
Outstanding contribution to the development.
Tushar Hemani, on behalf of Tushar Hemani. The Best Zone Chairman Award once again goes to Mr. Anand Kumar Pandey. आनंद जी आप यहाँ खड़े रहिए, बार बार बुलाना नहीं पड़ेगा आपको. From North Zone, as a chairman of the North Zone. Now the next award goes to the final one, my zealous, enthusiastic, moral, ethical, Mr. Santosh Gupta as Secretary General, sir. Sir, I have expressed my feelings. Finally, sir, the ceremonial part, finally, we begin the ceremonial part. I, from this platform, as a National President of All India Federation, officially declare the recommendations of Collegium for the National Presidentship of 2026 bestowed upon my very good friend, Mr. S. Venkatramani. I would now officially hand over the corner to him, and thereafter it would be the oath-taking ceremony, once again by the Ganapati of AIFTP and Supreme Court.
I,
Satyamurthy Venkatramani, swear in the name of God and solemnly affirm that I will bear true faith and allegiance to the Constitution and bylaws of All India Federation of Tax Practitioners as by law constituted.
that I
Will faithfully uphold the standards of professional conduct and etiquettes of the Federation. That
I
will faithfully and conscientiously discharge my duties as the President for the Federation.
and that I
Will do the right to all members of the Federation in accordance with the Constitution and bylaws of the Federation without fear or favor, affection or ill will.
I
Satyamurthy Venkatramani, swear in the name of God and solemnly affirm that
I
will not declare, directly or indirectly, communicate or reveal to any person or persons any matter which shall be brought under my consideration or shall become known to me as the President for the Federation, except as may be required for the due discharge of my duties as the President.
Thank you. Congratulations.
Thank you, 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 thank you. Venkat sir.
Ladies and gentlemen, I now take immense pleasure to invite our newly elected National President of All India Federation of Tax Practitioners, CAS Venkat Ramani, to deliver his address.
Good morning, esteemed Chief Guest, Honorable Justice Ujjwal Buyan, Judge, Supreme Court of India, Guest of Honor, Honorable Chief Justice of Karnataka High Court, Sri Vibhu Bakri, my outgoing National President, Samir Jani, my good friend, Secretary General Santosh Gupta, my revered mentor, Guru, and National Convention Chairman F.R. Singhvi, distinguished and accomplished Convention Co-Chairman Padamchand Kincha, my beloved Conference Secretary Prashant, I can't see him, yes, Prashant, respected past presidents of the Federation who are seated right from P.C. Joshi, Nikita, Madam, Shivram, Sir, all I can see, yes. Past chairpersons of Bangalore branch of SARC, there are a number of them who are here, who are my very, very good friends. I don't know if the past president of ICI, Mr. Raghu, is here. I saw him sitting here. Yes, I saw him sitting here. We have of the past presidents of the Karnataka State Chartered Accountants Association, the secretaries of the Bangalore branch of ICI, etc. My friend and chairman of Bangalore branch of SARC, Mr. Manjunath, President of KSC, Mr. Shiv Prakash, office bearers, and chairman of all the 5 zones of All India Federation of Tax Practitioners, eminent session chairpersons whom some of you I see here, paper writers for the souvenir, speakers, moderators, brain trustees, and members of the 28th National Convention. Tax professionals have gathered here in the spectacular auditorium in large numbers, including some students who have been attending for the first time, including students of law who have been here, been invited here to witness this two-day event, and all other distinguished delegates. Your Lordships, we have amongst us delegates from Leh Ladakh to Kanyakumari in the south, and from Itanagar in the east to Bhuj in the west. We have delegates from 21 states and 3 union territories in this gathering. It is with profound humility and a deep sense of responsibility I stand before you, having been entrusted with the honor of serving the All India Federation of Tax Practitioners as its president for the year 2026, which also happens to be, my lords, the Golden Jubilee year of the All India Federation of Tax Practitioners. I'm truly humbled and with a deep sense of gratitude to this august gathering and to every member of our federation across the length and breadth of India who have placed their unflinching trust on me, the members of the collegium who placed their trust on me, the past presidents, including the zone chairman and the office bearers of this association who have placed this, I promise you that I will uphold the values, traditions, and high standards set by this great institution over the past 50 years. Permit me, my lords, to first acknowledge a few organizations and individuals whose guidance and leadership have shaped my career over the last 30-odd years. First and foremost, my principal, Mr. M.R. Rangaratnam, who taught me what discipline was. My lords, it was one of those days. Our office would start at 9:30. I reached there probably at 9:40. It was just 21-year-old. My lords, you know that it's good to go 5-10 minutes late. I was told, you are too early for tomorrow, get out. Those were the learnings, and that is the discipline that I have inculcated till today. So first was my M.R. Rangaratnam. My firm, Singhvi Devandundi, where I spent 30 years, 29 years and 11 months to be precise. And a good part of that as a partner, including in the formative years of my career. It was my firm which stood by me. I started my practice with Singhvi Devandundi in income tax, Mr. Padam Kincha, and I looked around and I found people like Padam, again, Devraj, Ram, Vishnu, Vinay, Lakshmi, Manoj. I don't know if all others are there, Ramarao, whom I can remember. They are all here today. Rangnath, Partha, etc. This firm has blossomed into one of the finest firms in India, as the success story of SGO has been phenomenal. A word has to be told about my Guru F.R. Singhvi, who is the National Convention chairman, who has steered this convention to wherever it is today. Personally, F.R. has been my guru, my friend, my philosopher, my mentor, my guide, call by whatever name. He has been a constant source of strength for me. I remember one incident when I ran to Devraj sir and told him, when I had fought with a commissioner and told him, you have a pen and paper, you write whatever you want. So I came back and told Devraj sir proudly that this is what I told the commissioner. He said, what have you done? What have you done? This is not how you do to officers who hold public office. You go back, you apologize. I had to go back with a bouquet, apologize, get back. And that was the discipline that this firm and my partners taught me. My appreciation cannot go without talking about Padam Chand Kincha, our brilliant, diligent, hardworking, and dynamic co-chairman, who has meticulously planned this entire conference with unwavering commitment. Padam sir, I don't know how many times we have disturbed you through the night and day. You have ensured that this national convention stands as one of the finest in recent memory. Thank you, Padam sir, for whatever you have done. Welcome to this conference. My outgoing President Samir Jani and Secretary General Santosh Gupta, your leadership abilities during the testing times that we have had in this year. We have had some of the best moments of the year. We have also had some testing times during the year. And to steer this organization through the turbulent times that we have gone through during the year, I think with such grace, welcome Mr. Samir Jani and Santosh Gupta to this conference. I'm deeply honored by my lords, Justice Ujjwal Bhuyan and Honorable Chief Justice of Karnataka High Court, your lordships. Your presence elevates this inaugural conference, inaugural event, and reminds us of the profound responsibility that we carry as tax professionals in contributing to the rule of law, and to the nation's economic framework, in nation building. Your lordships, let me assure you that during my tenure, I will uphold the motto of the Federation: ethics, education, and excellence. We will do all it takes to reach our destination, to reach the education to the last man standing, Our efforts will be on. We will try to reach education to the last man. With these words, it is my pleasure to welcome your lordships to this national convention. My journey with this federation spans 28 years. First few years, when I was not a member of this federation, I would travel with my FR Singhvi, writing some papers, whatever little I knew for him. He would deliver the lecture, come back, correct all the mistakes that I had done in that paper, because he would have delivered something more than what I have written in those papers. Starting from 1997 onwards, I became a life member of this federation in 2006, 19 years back. I have held various positions in this federation. I've never aspired for any position in the federation. I have worked with commitment, with dedication to the extent possible, and this is where this federation has made me stand today as the president for the year 2026. Thank you, All India Federation of Tax Practitioners. I cannot forget two of my alma maters, the Bangalore branch of SARC, currently whose chairman is Manjunath, and the Karnataka State Chartered Accountants Association, who have given me this platform. I don't know, several hundred times as a speaker. To be on this side of the stage and not speaking on a subject is very, very difficult for me. But it is these two associations who have elevated me to this position. Thank you, Bangalore branch. Thank you, Karnataka State Chartered Accountants Association. The theme of this conference, honoring the past, inspiring the future. In this iconic setting of the Bangalore Palace, it bears testament to the collective effort of the various committees that have functioned for this national convention. And the sponsors and contributors for this conference, you will not find a single name here with the name of the contributor or donor. That is testimony to how many of them have quietly supported this national convention. There are many of them who are our friends. There are many of them who come from the Bangalore branch and Karnataka State Chartered Accountants Association. Our theme, therefore, could not be more appropriate, honoring the past and inspiring the future. My lords, as the Federation progresses into the Golden Jubilee year, I promise you, our legacy, our foundation, our responsibility will be unflinching insofar as this Federation is concerned. In this national convention, we are privileged to have some of the finest speakers and thought leaders of tomorrow. You will see them speak over the next 2 days. The partnership of Karnataka State Chartered Accountants Association and Bangalore branch of ICI cannot be mentioned in words. You are seeing all of this in action. Before I conclude, my lords, as I look ahead for this federation during my tenure, there are 3 things that I will endeavor to the best of my ability. 1, knowledge empowerment. I will try my best. I will strive for it to reach knowledge to the extent I can. 2, collaboration and inclusivity. I will collaborate. I will include as many people as possible who will take me along with them. It is not that I take them along with me. They will take me along with them and take this institution of the federation to better. 3, my lords, service to this federation will also mean service to the nation. Service to the nation and the profession. I can only assure this August gathering that we will uphold ethics. We will uphold the policies of the policy framers, whether it is the government, center, or state, or local authorities. We will try and uphold that. We will suggest reforms. We will be a part of the reforms. We will try and drive reforms if it is possible. And we will make this stronger through leadership of the association, whose integrity will be admired across the nation. My Lord, thank you very much. I have taken time, and to all the delegates today here, thank you for your enthusiasm, thank you for your support, and thank you for your belief in the Federation's mission. I look forward to working with each one of you in the coming years. With humility in my heart and commitment in my actions and my prayers to the Almighty, I accept this responsibility and seek your continued guidance and indulgence. Thank you.
Thank you so much, sir, for those personal and inspiring words. We now invite CA Manjunath Hallur, Chairman of the Bengaluru branch of ICAI, to introduce today's guest of honor, Honorable Mr. Justice Vibhu Bhakru, Chief Justice, High Court of Karnataka.
Good morning, ladies and gentlemen, dignitaries on the dais and off the dais. This is CA Manjunath M. Hallur, Chairman of Bangalore branch of SIRC of the Institute of Chartered Accountants of India, the largest and one of the most vibrant branches of ICAI in the country, consistently at the forefront of professional development and knowledge dissemination for all of our members. It is indeed a privilege and honor to introduce to this august gathering today's guest of honor, an eminent jurist who stands at the unique intersection of two great professions, accountancy and law. Honorable Mr. Justice Vibhu Bhakru, the distinguished Chief Justice of High Court of Karnataka, was born in Nagpur in the year 1966 and completed his schooling at Delhi Public School, Madhura Road, New Delhi. His professional journey began with the Institute of Chartered Accountants of India when he commenced his articles with Messrs. Thakur, Vaidyanath Iyer and Co. in March 1985. He earned his BCom Honours degree from Delhi University in 1987 and qualified as a chartered accountant in 1989. Driven by a deep interest in the legal domain, he pursued and completed his LLB in 1990 and thereafter enrolled as an advocate with Bar Council of Delhi. Justice Bhakru went on to build an illustrious practice, appearing before Supreme Court of India, the Delhi High Court, Company Law Board, and various tribunals. His legal acumen earned him the prestigious designation of Senior Advocate by the Delhi High Court in July 2011. His judicial career commenced with his appointment as Additional Judge of Delhi High Court in April 2013, followed by his elevation as Permanent Judge in March 2015. He also served with distinction as the Acting Chief Justice of Delhi High Court from December 24 to January 25. In July 2025, he was appointed as Chief Justice of High Court of Karnataka, a role in which he continues to command great respect for his scholarship, humility, and unwavering commitment to justice. We are truly honored to have His Lordship with us today. May I now request all the distinguished delegates here to join me in extending a warm round of applause and in welcoming Honorable Justice Vibhu Bhakru, Chief Justice of High Court of Karnataka. I request His Honorable Justice Vibhu Bhakru to address the gathering and share your insights and wisdom. Thank you.
Honorable Justice Ujjwal Bhayan, Judge of the Supreme Court of India, Mr. S. Venkatramani, who's President of this federation, and Mr. Samir Jani, who has just handed over charge. Must acknowledge Mr. B.C. Joshi, one of the seniors who's present here. Mr. Singhvi, the Chairman, Mr. Parmanand Kincha, Co-Chairman, and all members of the National Executive and the Zonal Committees of All India Federation of Tax Practitioners, all the dignitaries on and off the dais, learned senior advocates, chartered accountants, company secretaries, the respected speakers, ladies and gentlemen. A very good morning to all of you. It is an occasion of significance to join you all for the 28th National Convention of the All India Federation of Tax Practitioners here in this historic city of Bengaluru, a city that stands at the crossroads of technology, innovation, entrepreneurship, and governance. The presence of such an extraordinary gathering of professionals from across India is itself a testament to the strength of AIFTP and its enduring commitment to the growth of our nation's ecosystem. The presence of Honorable Justice Ujjwal Bayan, Judge, Supreme Court of India, underscores the importance of discussions relating to tax administration and legal reform. Before I proceed, I would like to acknowledge the Karnataka State Chartered Accountants Association, the Bengaluru branch of SIRC of ICAI, and the AIFTP South Zone for organizing this national convention with such precision and dedication. The impressive program spread over 2 years from intricate discussions on income tax issues, real estate taxation, GST, appellate practice, technology, AI in practice, and the brain trust sessions reflect the rigor and the diversity that AIFTP has always been known for. The All India Federation of Tax Practitioners, as many of you know better than I do, was born out of a visionary aspiration, the aspiration to create a common national platform for all tax professionals, irrespective of their individual affiliations or professional identities. The AIFTP, I'm informed, was established on 11th November 1976 at a national conference of the Chamber of Income Tax Consultants in Mumbai, attended by eminent jurists including Justice Shah and Dr. Palkaiwala. Shri N.C. Mehta became the founder president and Shri P.C. Joshi was here the founder secretary general. Since its inception, the Federation has grown into a national body comprising of senior advocates, chartered accountants, company secretaries, cost accounts, and tax practitioners from all states and union territories. With more than 11,000 life members and 146 affiliated organizations, the Federation functions today as a national platform for tax professionals. I'm informed that Federation has been involved in several areas that contribute to development of tax, law and jurisprudence, continuing education, research publication, public interest litigations, and law reform. Its journals, newsletters, publications, and annual digests have been used by professionals across the country. The filing of 37 public interest litigations on questions of tax administration indicates the organization's engagement with issues affecting public domain. Members of the Federation have also gone on to serve in constitutional courts, tribunals, and as law officers, which reflects the professional background available with the body. The Federation, I'm told, has also undertaken certain initiatives of social and institutional nature, including the adoption of the Code of Ethics, the establishment of welfare corpus, conducting numerous seminars during the pandemic, and earlier dedicating a publication to Kargil war heroes and contributing the proceeds to Defense Fund. The release of a postage stamp honoring Dr. N.A. Palkaiwala was also facilitated at its request. I note the publication titled Cybercrime and Financial Offenses. Financial offenses today utilize digital tools such as QR codes, SIM swaps, deepfakes, AI-based impersonation, and ransomware. Cybercrime is developed into a large-scale borderless activity supported by complex digital networks. A practical guide for citizens, enforcement agencies, and practitioners is therefore timely as digital crime increases at a pace faster than conventional enforcement mechanisms. With India moving towards a highly digital financial system, public awareness and professional preparedness will be essential. A publication of this nature may assist both professionals and members of public in dealing with such offenses. The sessions planned over the next 2 days cover areas that reflect the transition currently underway in India's tax structures. Technology is now an integral to compliance systems, including e-verification, AI-based risk assessment, and invoice matching. The establishment of GST Appellate Tribunal is expected to be a key development in appellate framework. For India's long-term goals towards 2047, issues of simplicity, predictability, fairness, and technological advancement in tax administration will remain central, and the professionals will have a role as intermediaries between policy and implementation. The functioning of tax adjudication and appellate forums is a subject of continuous relevance. Their efficiency depends not only on judicial capacity, but also on the nature of assistance provided by the bar. Increasing complex tax matters involving digital evidence, cross-border transactions, and detailed statutory schemes require high standards in pleadings and advocacy. Professional ethics remains the foundation to maintaining trust between the bench and the bar. It is necessary to reiterate that taxation fundamentally concerns public interest. It is structured dialogue between state and citizens. Tax professionals play a role in safeguarding taxpayers' rights, enabling voluntary compliance, preventing arbitrariness, and continuing discussions on reform. They also assist courts in interpretation of taxation statutes in accordance with established principles. This contributes to the institutional stability and ultimately to nation building. I remember when I started my articles in 1985, the tax audit had just been introduced. The certificate to be provided by chartered accountants was that the accounts are true and correct. Now this, I remember, really shook our firm. Everybody put their heads together and said, true and fair we can understand, but now that it's a paradigm shift, we have to say true and correct. And we sat there for 2 months. We made an audit manual. It was my first assignment to make an audit manual for a tax audit. When I look back now 40 years and look where we have gone, and I was just speaking with Mr. Singhvi here, and he was saying, look at the transformation. From then to now, I don't know how many sections have been added into the Income Tax Act, how many of them have been deleted, how many of them have been amended. Possibly, as we know, several over the years. The book is now almost twice as thick as it was read earlier. Nobody had thought of how technology would play. Audit was a very simple exercise. You began by going to a firm, your industry, and asking them, give me a carbon paper and pen and I'll tell you my requirements, ledger, account book, pencils, red pencils to do your ticks, and that's how we started. Today, it is all tool-based. These 40 years have been so transformative that persons of my vintage, if they are not regularly looking at it, would have no idea of where this profession has gone. On the bench, we do several matters, several rosters and several assignments. Every 3-4 years, when you come back on the tax roster, you have to relearn the tax again because so much has happened. The profession will evolve further with technological change. Artificial intelligence will undertake many routine tasks, but the functions of judgment, analysis, and advocacy will continue to depend on human professionals. Future track practice will require multidisciplinary understanding, technology, digital forensics, financial regulation, international taxation, and data protection, amongst others. Public legal education will also become increasingly important in a digital economy. The program of this convention addresses many of these themes. The vision for 2047, GS80 practice, input tax credit, real estate taxation, artificial intelligence, and structured expert discussions. Such platforms enable informed engagement on issues affecting tax administration and practice. As I address this gathering, it's clear that the Federation has traveled a considerable distance from its inception in 1976 to its position today as a national professional body. The publication on cybercrimes released, which is going to be released today, is a continuation of its engagement with contemporary challenges. I note the efforts of those involved in preparing the publication and organizing this convention. I trust that the deliberations over the next 2 days will contribute meaningfully to professional discourse. Thank you. Jai Hind.
Thank you so much, Your Lordship, for those enlightening and insightful reflections. It is now my privilege to invite CA Shiv Prakash Viraktamat, President of Karnataka State Chartered Accountant Association, to introduce today's chief guest, Honorable Mr. Justice Ujjal Boyan, Judge, Supreme Court of India.
Good morning, ladies and gentlemen. On behalf of the Karnataka State Chartered Accountants Association, co-host of this prestigious 28th National Convention of the All India Federation of Tax Practitioners, it gives me immense pleasure to extend a warm and heartfelt welcome to all the distinguished delegates gathered here from across the country. We are honored by your presence and deeply grateful for your participation. As a 69-year-old CA association with more than 4,250 life members across India, it is my profound honor as President of the Karnataka State Chartered Accountants Association to introduce a towering luminary of the Indian judiciary. Honorable Mr. Justice Ujjwal Bhoyan, Judge, Supreme Court of India. His Lordship was born on 2nd August 1964 in Guwahati into a family with a distinguished legacy in law and public service. His father, Shri Suchendranath Bhuyan, served as a senior advocate and former Advocate General of Assam, a legacy of integrity and public service that Justice Bhuyan has carried forward with distinction. His Lordship's academic journey began at Don Bosco High School, Guwahati, continued through Cotton College, Guwahati, and later graduating in arts from Kirorimal College, Delhi. He obtained his LLB from Government Law College, Guwahati, and LLM from Guwahati University. Enrolled in 1991, Justice Bhuyan practiced extensively before the Guwahati High Court and its benches in Agartala, Shillong, Kohima, and Itanagar, as well as before the Central Administrative Tribunal and various civil and revenue forums. He served the Income Tax Department for 16 years as Junior Standing Counsel, beginning in 1995 and rising to Senior Standing Counsel in 2008, a role that makes his Lordship's presence today especially meaningful for a convention of tax professionals. Justice Bhuyan is also a member of AIFTP. Justice Bhuyan also held several important positions, including additional government advocate for Meghalaya, Special Counsel for the Forest Department, Government of Arunachal Pradesh, and later Standing Counsel for the Guwahati High Court. His impeccable reputation led to his designation as Senior Advocate in 2010, and soon thereafter he was appointed Additional Advocate General of Assam. His elevation to the bench came in 2011 as Judge of Guwahati High Court. He later served as Executive Chairman of the Mizoram State Legal Services Authority. Justice Bhuyan's judicial journey then took him to the Bombay High Court in 2019 and subsequently to the Telangana High Court in 2021, where he was appointed Chief Justice in June 2022. As Chief Justice of Telangana High Court, he also served as Chancellor of National Academy of Legal Studies and Research, strengthening India's legal academic ecosystem. On 14 July 2023, his Lordship was elevated as Judge of Supreme Court of India, following the recommendation of the Supreme Court Collegium. Justice Bhuyan remains closely connected to legal education and thought leadership. He is a member of General Council and Executive Council of National Law School of India, University, Bengaluru, and the General Council of Maharashtra National Law University, Aurangabad, shaping the next generation of lawyers and scholars. Honorable Mr. Justice Ujjwal Bhuyan's journey is one of scholarship, service, and steadfast commitment to justice. His contributions to taxation law, constitutional jurisprudence, and institutional development stand as an inspiration to both the legal and CA fraternity. Ladies and gentlemen, it is a matter of great pride for KSCAA, AIFTP, Bengaluru branch of ICAI, the entire tax and legal community, to welcome among us a jurist of such stature and wisdom. With great respect and privilege, I invite Honorable Mr. Justice Ujjwal Bhuyan, Judge, Supreme Court of India, to kindly address the August gathering.
The most erudite Chief Justice of Karnataka High Court, Justice Bibhu Bhakru, the President of AIFTP, Mr. Venkat Ramani, the immediate past President of AIFTP, Mr. Samir Jani, Mr. Singhvi, Mr. Santosh Gupta, Mr. Shiva Prakash, Manjunath Hallur, Mr. P.C. Joshi, the Founder Secretary General, all senior members who are present here, distinguished delegates who have come across the length and breadth of India, as the President has said, students, and my friends from the media. A very good morning to all of you. I'm very happy to be present here this morning in the garden city of Bengaluru for the inaugural session of the two-day convention 2025 of the All India Federation of Tax Practitioners. My congratulations to the outgoing team of officials led by Mr. Samir Jani, the outgoing national president, for all the good work done. And my best wishes to the new team of officials led by Mr. Venkat Ramani, the new national president, for all the future endeavors. Incidentally, this year also marks the golden jubilee of AIFTP. Founded at Mumbai in 1976 with the objective of having a common platform of all tax practitioners, AIFTP has come a long way. It had the blessings of celebrated jurists and judges in this journey of 50 years, including the former Chief Justice of India, Justice J.C. Shah, and distinguished jurist Padma Vibhushan Nani Palkhiwala. It's a matter of great pride for all of us that its founder Secretary General Shri P.C. Joshi continues his vibrant association and maintains an evergreen presence in the Federation. Friends, 50 years is a significant milestone in the journey of any institution or organization. It not only calls for celebration for all the achievements and successes, but it is also a time for reflection. I strongly believe that introspection is crucial. Only if we introspect or reflect upon can there be course correction. So my heartiest congratulations to the AIFTP for completing 50 glorious years. My best wishes to all the other organizers of this convention. I was very recently, as was pointed out by Mr. Singhvi, I was very recently present in the two-day National Tax Conference coinciding with the Golden Jubilee celebrations of AIFTP at Kolkata on November 8, 2025. But please don't be worried. I will not repeat what I had said in Kolkata. Friends, there can be no denial of the fact that state is the biggest litigant in this country. Sitting on a bench every day, we come across a number of special leave petitions being filed by the revenue, which are either hopelessly barred by limitation or are on issues which are purely of factual nature. Some SLPs are filed even when issues raised therein has already been answered by the court. This is true in respect of appeals under Section 260A as well. One reason for filing of such appeals and SLPs could be the tendency to play safe. Revenue officials tend to leave it to the court to take a decision one way or the other, rather than taking it upon themselves so as to avoid departmental and vigilance action. This has resulted in filing of a large number of SLPs and appeals by the revenue, which are either without any merit or are hopelessly barred by limitation, consuming substantial time of the court, not to speak of the time spent in the department while processing the appeals and special leave petitions. There can be one more reason for this, though there are no statistics to support this view. Because of the very nature of the proceedings, officials connected with assessment and investigation ordinarily are not willing to concede and continue to maintain an adversarial stance. This is true both for direct taxes as well as for indirect taxes. As a result, despite various settlement schemes or legacy dispute resolution schemes, revenue officials continue to contest the settlement applications, some even right up to the Supreme Court. The present Income Tax Act is on the statute book for more than 6 decades now. No doubt, it has served its purpose with a significant body of case laws evolved over the years. But at the same time, it goes without saying that with its large number of sections comprising multiple subsections, unlimited clauses, explanations and provisos, it is a nightmarish experience. It takes lesser time to deal with the meat of the matter than the time taken to locate the appropriate provision. With hundreds of amendments, the Income Tax Act 1961 has become a labyrinth of sections and subsections, making things extremely complicated for taxpayers and professionals alike. Rule of law requires that the tax regime must be fair and transparent. There must be predictability and certainty in the applicability of the tax laws. Investors, both domestic and foreign, want certainty. They don't want to face a situation where, based on today's law, they make investments, and then tomorrow they are told that the law which prevailed a decade ago or even beyond will be applicable. Retrospective tax provisions have dented India's image globally. This issue needs to be addressed. That apart, the overbearing nature of the tax regime in India has left many assessees frustrated and investors apprehensive. Not only are they confronted with multiple notices and summons, but they also have to deal with a highly layered adjudicatory process, which is often complex and time-consuming. To have a robust tax regime which is fair, transparent, and predictable, tax administration and the tax bar must be on the same page. They are not adversaries in that sense, but are equal stakeholders to achieve a common goal. While consistency is the hallmark of a mature tax regime, the adjudicatory process also needs to be fast-tracked to instill confidence amongst the assessees and investors. Friends, a new Income Tax Act is now on the anvil. The Income Tax Act 2025. It will come into effect from April 1st, 2026. Though it is claimed that it has simplified the language and procedure by removing obsolete provisions, critics are not convinced. The present Income Tax Act has 298 sections, besides 14 schedules. On a cursory glance, I have noticed that the new Income Tax Act has as many as 536 sections and 16 schedules. Revenue says that the new act has simplified taxation slabs besides rationalizing exemptions and integrating digital compliance mechanisms. However, it is being critiqued on the ground that the changes sought to be introduced are too superfluous to the revenue, premised on the suspicion of undisclosed income. As the new Income Tax Act introduces concepts like virtual digital assets, and as our lives and business moves into the digital space, apprehensions have been expressed in conscious quarters that the new bill may extend such powers into the digital sphere as well. Besides, apprehension of breach of privacy has also been raised. It would be appropriate if such concerns, which would have troubling implications for business autonomy, constitutional rights, and individual liberty, are addressed. Friends, taxation laws are part of the larger Indian jurisprudence. The tax bar is also a part of the larger Indian bar. The tax bar is also equally concerned with issues confronting the justice delivery system in India. I am certain the tax bar would join hands with the larger family of Indian bar to fight for causes and uphold issues which are central to Indian judiciary. As I had said, I won't repeat what I had said in Kolkata, but let me just start from where I left in Kolkata. In Kolkata, we discussed about the life of Nani Palkewala, arguably India's greatest constitutional lawyer and tax lawyer. And in that context, we also discussed about the various important decisions of the Supreme Court which were influenced to a great extent by Mr. Palkewala. I had mentioned about the 13-judge bench decision of the Supreme Court in Keshavananda Bharati versus State of Kerala in the Kolkata conference, and how this judgment is considered to be the greatest constitutional case of all times. I will not go into the nitty-gritty of the judgment. This judgment declared that there are certain basic or essential features of our constitution which cannot be changed or altered through the process of amendment as provided in Article 368. Following Keshavananda, Supreme Court has delivered numerous judgments reaffirming the doctrine of basic structure. It is due to the jurisprudence developed by and post Keshavananda that rule of law, independence of judiciary, judicial review, and democracy, amongst others, are now firmly established as basic features of our republic. I'll dwell on this a little bit more, but let me turn a few pages back in history when we discuss about the concept of judicial independence, independence of the judiciary. In June 1948, Sir Harilal Kania, he was then the Chief Justice of the Federal Court of India. He delivered a widely circulated public address while presiding over inauguration of the Assam High Court, which is now the Guwahati High Court, which incidentally was the first High Court established in independent India. In that speech, he not only broke a tradition of judicial reticence, but more importantly highlighted the need for judicial independence, which he was unable to do as a member of the colonial judiciary. Chief Justice Kania's speech was one of several public and private initiatives by the Indian judiciary to shape the contours of the draft constitution, which was then being debated in the Constituent Assembly. Archival materials show that almost all sitting judges, whether in the high courts or in the federal court, actively pushed for changes in the draft constitution, seeking to ensure an autonomous judiciary. Upon reading portions of the draft constitution, Chief Justice Ramlal, who was the Chief Justice of the East Punjab High Court then, he wrote directly to Jawaharlal Nehru, expressing his concerns about certain provisions dealing with the judiciary, which he thought had the potential to do incalculable mischief. Nehru forwarded Chief Justice Lal's letter to the Constituent Assembly Secretariat. Perhaps anticipating a flood of such correspondence, the Secretariat officially invited all High Court judges to submit their comments on the draft Constitution. Close to 100 High Court judges offered individual feedback, while some of the High Courts additionally offered collective statements. The judges collectively and individually stressed upon the need for judicial autonomy, uncompromised by the power of a popularly elected executive. Chief Justice Shivde of the Nagpur High Court, unfortunately, on the reorganization of states, Nagpur High Court became a bench of the Bombay High Court. Now, Justice Shivde, in a lyrical manner, he wrote that the executive in a democratic state was bound to be a fluctuating body. Like the clouds, it may come and it may go. Therefore, it should not be allowed to exert its influence over the judiciary by arrogating the power to control it. Thereafter, the Supreme Court was set up. We had the Constitution. 2 days after the Republic Day, the Supreme Court of India had its first sitting by the Chief Justice Kania and all the 6 judges. In that inaugural speech, Chief Justice Kania stressed upon, amongst others, he said many other things, the importance of an independent judiciary, asserting that the Supreme Court must operate independently of the legislative and the executive branches. By insisting on judicial independence, Chief Justice Kania sought to ensure that the judiciary can check misuse of power by the legislature and by the executive, safeguarding democracy and individual rights. Friends, now that we are talking about judicial independence, there are 2 provisions in the Constitution, Article 214 and 217, 124 and 217, which provides for appointment of judges to the High Court and to the Supreme Court. The original text mandated that every judge of the Supreme Court shall be appointed by the President after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose. Similar was the provision for appointment of High Court judges. In 3 separate judgments, Supreme Court gave a new interpretation to the word consultation by declaring it to mean concurrence, thus leading to the collegium system. I believe that having regard to the malady of political influence and executive interference, playing a disproportionate role in the appointment of High Court and Supreme Court judges, the collegium system was the need of the hour. I myself is a product of the collegium system. As a High Court judge, as a Chief Justice of a High Court, and now as a judge of the Supreme Court. To a large extent, we can say that the collegium system was successful in keeping executive and political influence at bay in the process of judicial appointment. There are critics who were and who continue to remain highly critical of the collegium system. I admit they may have a point or two. I'm not saying that the collegium system is a perfect one. But if you look at various other options at the table, I think the collegium system is better than the other alternatives which are on offer. So in 2014, the Constitution 99th Amendment Act was enacted, and so also the National Judicial Appointments Commission Act was enacted, which sought to replace the collegium system by the National Judicial Appointments Commission with two eminent jurists and the law minister as member. This was challenged in the Supreme Court by the Supreme Court Advocates on Record Association. Supreme Court, by majority 4:1, struck down the Constitution Amendment as well as the Act on the ground that those impinged upon the independence of the judiciary and were also violative of the principle of separation of powers between the executive and the judiciary, which formed part of the basic structure of our Constitution. I was then a judge in the Guwahati High Court. There was a television debate. I think it was NDTV, television debate. We had Arun Jaitley, the then Union Law Minister, on the one hand, and representing the judiciary, we had Justice Lodha, R.M. Lodha, the former Chief Justice of India. Now I can tell you that since last 3 years, I have stopped watching television. I don't watch television at all nowadays. But during those days, I used to watch a little bit. Now, in this debate, Jaitley was so upset with this judgment that he criticized it as a tyranny of unelected judges. He said it openly. It's a tyranny of unelected judges. According to him, judges are not elected. Members of parliament are. Not only they draw their authority directly from the people, but are also answerable to the people. Lawmaking is within the domain of the parliament. Therefore, Supreme Court ought not to have set at naught the will of the people, manifest in the form of the Constitution Amendment and enactment of the law. However, according to me, this criticism that unelected judges of constitutional courts should not interfere in the lawmaking by elected representatives of the people has no legal or constitutional basis. This is because the Constitution has mandated the Supreme Court and the High Courts the power to examine whether the law made by the Parliament or by the legislature conforms to the constitutional requirements, and if not, to strike down such law by exercising the power of judicial review. Supreme Court had exercised the power of judicial review, which is a basic feature of our Constitution. Friends, the narrative doesn't stop there. Now that judiciary has repelled officially the government's initiative to replace the collegium system, it becomes the bounden duty of the judiciary itself, more particularly the members of the collegium, to ensure and uphold the independence of the judiciary, to ensure that the collegium functions independently, and that integrity of the collegium process must be maintained at all cost. As judges, we have taken a solemn oath to uphold the Constitution and to perform our duties without any fear or favor, ill will or affection. We must remain true to our oath. Therefore, it is primarily the duty and responsibility of the judges to uphold the sanctity and integrity of the judicial process, including the collegium system, thereby the independence of the judiciary. I assert that independence of the judiciary is non-negotiable. Caroline, I referred to this in a recent speech in Pune, organized by the Bar Council of Maharashtra and Goa regarding to bid farewell to Justice Oak. I referred to Caroline Kennedy, the daughter of John F. Kennedy, one of America's most loved presidents. Caroline was herself an eminent personality, an attorney, distinguished author, and a diplomat. In a context in America, she had said, "The bedrock of our democracy is the rule of law. And that means we have to have an independent judiciary. We need judges who can make decisions independent of the political winds that are blowing." I repeat, we have to have an independent judiciary with judges who can make decisions independent of the political winds that are blowing. If it is true for America, it is equally true for India, if not more. We need bold and courageous judges to uphold the rule of law and to protect the independence of the judiciary. There are other things also. I would not like to go into that. The Chief Justice is present. I will refer to it in some other occasion. I have 2-3 speeches lined up in January. I will say this. I will speak my mind in those speeches. But before I end, rule of law and an independent judiciary are the sine qua non for a healthy democracy, which depends on, which acknowledges a spirit of accommodation. The Indian bar, of which the tax bar is an important member, must strive for upholding the basic features of our Constitution and our Republic. Thank you very much, and God bless.
Thank you so much, sir, for your thoughtful, provoking, and inspiring address that has enriched this morning with wisdom. Ladies and gentlemen, now we move towards one of the most significant and symbolic moments of today's event, the souvenir release ceremony. A souvenir is not just a book. It is a reflection of thoughts, vision, memories, and collective efforts. May I request the esteemed individuals to please join the dignitaries on the dais. C.A. Padam Chand Kincha, C.A. Ravindra Kore, C.A. Raghavendra Puranik, C.A. Prashant G.S., and C.A. Siddheshwar Yelamali. Request all these individuals to join the dignitaries on the dais for the souvenir release. Ladies and gentlemen, please give them a huge round of applause. This moment celebrates the intellectual contributions that strengthen our profession and carry forward the legacy of learning.
Gentlemen, with this, we move to yet another very momentous moment. Bringing a book to life is a journey that demands immense effort, thoughtful research, and countless hours of dedication. With this spirit of appreciation, it is time for the book release. A special mention to our esteemed committee leaders who have given immense support to these publications: Advocate Nikita Bhadeka, Committee Chairperson; Senior Advocate Dr. K. Shivaram, Committee Chairman; and Advocate P.C. Joshi, past President. We have our first book, GST Case Law, Essential for Tax Professionals. The author, C.A. Jatin Christopher, and edited by C.A. Janak Baghani. I request the dignitaries to please release the publication. Ladies and gentlemen, a huge round of applause. Thank you so much. We now move on to the book 2.
The publication on GST is a historical job done by the Indirect Tax Committee Chairman, Nikita Badeka. It is after a very long time. Please give her a big hand.
Book 2, request author C.A. Siddesh Yalamali, C.A. Raghavendra T.N. and Advocate Bhanumurthy J.S. to please come on to the dais. The title of the book is Compendium of GST Case Laws.
Ladies and gentlemen, please give them a huge round of applause. Book 3, Cyber Crimes and Financial Offences. Dedicated to Operation Sindoor, in occasion of Golden Jubilee of AIFGP, all surplus proceedings will be going to the Prime Minister's Relief Fund. The book contains 11 chapters and 541 FAQs, offering clear and practical guidance on cyber crimes, financial frauds, tax issues, money laundering, and safety measures. It also features the Honorable Prime Minister Shri Narendra Modi's message on Operation Sindoor. Ladies and gentlemen, please welcome the author C.A. M.V. Purushottam and the panel of advocates, and the editor, Senior Advocate Dr. Shivram. Ladies and gentlemen, please give them a huge round of applause. Let me remind you once again, ladies and gentlemen, this book features the Honorable Prime Minister Narendra Modi's message on Operation Sindoor, and all the surplus proceedings will be going to the Prime Minister's Relief Fund. you so much, ladies and gentlemen. We now come to the moment of deep respect and heartfelt gratitude as we felicitate our honored guests. I request dignitaries on dais to recognize and honor our chief guest, Honorable Mr. Justice Ujjal Boyan, Judge, Supreme Court of India, for gracing this occasion with his distinguished presence and for elevating this inaugural session with his profound insights. Ladies and gentlemen, the post that this gentleman holds is no small thing. Let the applause continue and give a huge round of applause for our Honorable Chief Guest, Mr. Justice Ujjal Boyan. Thank you so much, gentlemen. Now, with immense pleasure, our guest of honor, Honorable Mr. Justice Vibhu Bhakru, Chief Justice, High Court of Karnataka. Ladies and gentlemen, please give him a huge round of applause for his invaluable presence. Thank you so much, dignitaries. Sometimes it is not just the post, not just the designation, but it is the people and their personality we respect them for. These honors are a small expression of our immense appreciation. With this, I now invite Convention Secretary CA Prashant GS to deliver the vote of thanks, a gesture of gratitude acknowledging the dedication, effort, support that have shaped this inaugural session with grace and excellence.
Good morning, all. We are indebted to our parents for life. We are indebted to our Guru for the way we live. This is a momentous occasion wherein I place on record my deep sense of respect and gratitude to my mentor, C.A.S. Venkatramani, who has been a guiding force and factor in my endeavor of profession. Also, my deep respects to C.A.D. Devraj, who has been a guiding force in my entire formatic practice. Why did I start with this in the vote of thanks? What is the bedrock of AFTP? This is the professional Guru-Shishya relationship and the professional brotherhood. That is the bedrock of AFTP, which is why I started with honoring my Guru. What makes it even more momentous is I am deeply obliged to be part of the convention where Venkat sir is taking over as the national president, and the occasion is that his mentor, Singhvi sir, he was my principal when I started my articleship. He is on the dais. So this makes it a double whammy for 28th National Convention 2025. Now, as Padam sir had instructed at the very beginning that time is the essence of this convention. And I believe we have lived up to it and ensured that within the time allotted, we are on schedule. I thank C.A. Manjunath, C.A. Shiv Prakash for their esteemed presence. Santosh Gupta ji, Secretary General of AFTP, thank you very much, sir. Samir Jani ji, National President AFTP, thank you for your words of wisdom. Singhvi sir, your association with AFTP and how it brought you back after 20 years would ensure that what AFTP stands for. Thank you for your guidance. And as usual, Padam sir is the opening batsman. He's a fast bowler when he was playing cricket, but here he was the opening batsman. Thank you for the wonderful comments. Venkat sir, in his President-elect speech, has laid out what he will be taking care. Thank you very much for your speech, sir. Honorable Vibhu Bakru, Honorable Justice, Chief Justice of High Court of Karnataka, he also laid out how AFTP began and how it has progressed. Thank you for your words of wisdom, sir. Last but not the least, Honorable Mr. Justice Ujjal Boyan, Judge Supreme Court of India, for his encouraging words and his constant support to the Federation. I also recognize the presence of Honorable Dr. Justice Anita Sumanji here. Thank you, Madam, for gracing this occasion. I also recognize the presence of Dr. Anand Ranganathan. Thank you for your presence, sir. Before we end, just a small announcement to be made as part of the AFTP. Golden Jubilee Convention has begun. It will go on for the next 2 days. As a part of the Golden Jubilee, we also have a NTC which is planned in 2026. That will be the first of the NTCs that AFTP will be embarking in 2026. That particular brochure, I would request Honorable Justice to release it so that once we end 2025 on the National Convention, we are beginning 2026 again with emphasis on ethics, education, and excellence. Finally, I thank all the participants here, the galaxy of past presidents, speakers of various technical sessions, chairpersons, past chairman of Bengaluru branch of ICAI, past president of Karnataka State Chartered Accountants Association, and all the delegates who have traveled from across the country. As Sir put it across his opening speech, we have delegates from 21 states and 3 union territories as part of this particular 28th National Convention. Thank you one and all. Jai Hind, Jai AFTP, Bharat Mata ki Jai.
Thank you so much, sir. Every individual in this hall has taken an oath to contribute collectively to the progress of our nation. With that, may I request everyone to kindly rise for the singing of the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you so much, ladies and gentlemen. We now invite all dignitaries for a brief photo session to capture this significant moment of unity, honor, and celebration. Ladies and gentlemen, this brings us to the conclusion of the inaugural session, a session enriched with wisdom, dignity, and inspiration. With that inspiring inaugural session, we now take a short but a refreshing pause. You know, conference runs on two things: great ideas and great tea. And after such a power-packed start, I think both are essentially important. We invite you to proceed for tea break. Kindly reassemble by 12 p.m. sharp. Thank you for your gracious attention.
ಆಫೀಸ್ ಆದ ನಂತರ ಆರ್ಮಿ ಮೀಟಿಂಗಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಿದ್ದೆ.
Ladies and gentlemen, I request all the
So you will be getting the...
Yeah, it's little away. Don't worry. If you can, I can see there, but I would like because. Yes.
Okay, if needed, I will get the laptop. We can add it in this. This is a remote. So if you just change, that automatically changes.
It is play if you have.
hall and grab your seats. We will begin the event shortly. I request all the individuals out there to please enter the hall and grab your seats. We will begin with our first technical session for the day.
So you want your control to be there. I'll get the laptop. We can add the slide changer and this thing here. Because if you change here, it will not get changed there. So you'll have to change here also.
So what do I do?
I'll get one laptop. You can change in that automatically. It is
So I will scroll down, right? No?
Yes, yes.
That's
You
it,
just
no?
scroll.
So I just exit from
I'll
this.
get the laptop. Yeah.
Ladies and gentlemen, all the delegates out there, I request all of you to enter the hall and grab your seats. We will begin with the first technical session, controversial and contemporary issues under income tax. Our first technical session for the day. Shortly, I request all the delegates out there to please grab your seats. The speakers are ready, the chairperson, the moderator are here. I request the delegates to please be here. We will begin the event in few minutes.
में केबल तक
Ladies and gentlemen, and now let us step into the intellectual arena with a subject that evolves faster than our morning emails: income tax. You know, income tax is that one syllabus where even silence has meaning, especially during scrutiny. This session today is chaired by the distinguished Honorable Dr. Justice Anita Sumant. Our speakers, CA Pradeep Kapasi, a stalwart who makes even the hardest tax controversies feel like a friendly conversations, and Senior Advocate Dr. K. Shivaram, a dynamic professional who ensures that every discussion is not just informative but perfectly orchestrated. May I now request Advocate Bhaskar and Advocate Smastin Dolma from Leh to escort our chairperson, Honorable Dr. Justice Anita Sumant, to the dais. Ladies and gentlemen, please give them a huge round of applause. Honorable Dr. Justice Anita Sumant, Judge, Madras High Court. Ladies and gentlemen, please give a huge round of applause for our chairperson, Dr. Justice Anita Sumant, who is qualified BA, BL Government Law College from Madras, ML in Constitution, Public International Law, University of Madras, PhD awarded by the National Law School of India, University, Bangalore, who joined the chambers of Senior Advocate Sri Ramachandran and practiced extensively before the Supreme Court, High Court, tribunals and other appellate forums, as well as the Authority for Advanced Rulings specializing in direct and indirect taxes and corporate laws. Ladies and gentlemen, please give a huge round of applause for the chairperson, Honorable Dr. Justice Anita Sumant. May I now request
Ladyship, you may recall that for the term 2014 and 15, you were the chairperson of South Zone. I was the secretary, zone secretary at that time. Thereafter, 2023, I was the zone chairman. 2024, I was the national joint secretary. And 2026, I'll be the Secretary General and you continue to be the chairperson. Thank you.
May I now request CA Siddesh Velamalli and AK Srivastav to escort our speaker for the event, CA Pradeep Kapasi.
Ladies and gentlemen, please give them a huge round of applause.
CA Pradeep Kapasi, a stalwart who makes even the hardest tax controversies feel like friendly conversations. He is a chartered accountant and a law graduate from the Government Law College. He leads the chartered accountancy firm Pradeep Kapasi & Co. located in Mumbai. He is the past president of the Bombay Chartered Accountant Society and the Chamber of Tax Consultants. He has co-authored many professional books. The titles include Taxation and Accounting of Shares and Securities, Fringe Benefits Tax, and other such books. He is a regular contributor of articles in the professional magazines. He is also on the editorial board of the Chartered Accountant Journal of ICAI, the Chamber's Journal, and discharge editorial functions for All India Federation of Tax Practitioner Journals and other such journals. Give sir a huge round of applause.
May I now request Advocate Sanjay Kumar to please escort Senior Advocate Dr. K. Shivram onto the dais. Ladies and gentlemen, please give them a huge round of applause. Our moderator for the first technical session, Dr. K. Shivram, a senior advocate, who is a designated senior advocate of Bombay High Court, practicing as counsel before Bombay High Court Income Tax Appellate Tribunal since 1978. The past president of the Chamber of Tax Consultant, Mumbai, 1990-1992. Past president of All India Federation of Tax Practitioners, 2003 to 2006. Past President of Income Tax Appellate Tribunal Bar Association Mumbai 2011 and 12. Former editor of Income Tax Review published by the Chamber of Tax Consultants Mumbai 1992 to 2001 and the chief editor of the AIFTP Journal since 1994 to 2018 and the member of Regional Direct Taxes Advisory Committee, Government of India since 1992 to 1996. Ladies and gentlemen, please give all the dignitaries on the dais a huge round of applause. May I now request our chairperson, Honorable Dr. Justice Anita Sawant, Madras High Court Judge, to please take over the further proceedings.
Good morning to all of you. It's, as always, a pleasure and a privilege to be back to the AIFTP. It's like a homecoming. There are so many familiar faces here. And I would like to thank Mr. Venkatramani for this invitation. My namaskarams to all the seniors here. I'm so happy to see the senior advocates, the senior chartered accountants, whom I have been seeing over the last 3 decades. And I miss the many faces that are not part of the audience now. But I'm very grateful that we still have the guidance of the seniors as we do now. My association with the AIFTP goes back about 3 decades. And I remember attending a conference, say sometime in 2010 or 2011, when the topic was the Direct Tax Code of 2010. The seniors here will remember that. Ultimately, that's a proposal that was not formalized and it was dropped. And here we are again today, after 15 years, with a brand new tax statute in hand. I would think that this goes to show that the process of updation of the laws takes this long. And it is only on the 21st of August of this year, 2025, when the new act has been passed, has been enacted. there is not too much material available in public domain about the new act itself. And all the discussions and the papers that are available deal with the new bill before it passed into an act. So I am a little wary about making any comments or observations because I have not had a chance to study the new act per se. And I would not want to go on the basis of the discussions available on the bill because there is always the aspect of those suggestions that were made after the bill was available in public domain and that figure in the new act. So I will leave that to the moderator and the learned speaker in the course of their presentations. Mr. Kapasi was very kind to recount a meeting that we had and a participation in a conference about 11 years ago in Pondicherry in 2014. And that, I think, is the beauty of an association like the AIFTP. It keeps the group together and keeps the intellectual juices flowing. He's forwarded me a presentation of about 66 slides on various aspects of the new Income Tax Act. And there's a lot of food for thought here. We can look forward to a very comprehensive and interesting discussion to follow. Now, in the rough reading that I have done of the new act, I find that practitioners today will have to unlearn and relearn some concepts that we are all used to. For instance, the concept of a unified tax year has now come in, as opposed to a financial year and an assessment year that all of us are used to. There have been some concerns about the intrusion of privacy because there were comparisons made with the ratio of the judgment in Puttaswamy's case, whether the new provisions would make any inroads into that. All this is a question only time will tell. But when I said unlearn and relearn, there is one caution that I will have to place here. These are very, very challenging times because the new act becomes effective from assessment year 2026-27, 1/4/2026. And my understanding of it is that it will apply only prospectively in respect of those proceedings initiated after 1/4/2026. So in respect of pending proceedings, you will have to remember your concepts in relation to the existing 1961 Act. So when I say challenging, it means that we will have to learn two different sets of concepts and principles relating to the 1961 Act as well as the 2025 Act. I just saw some new concepts, like you've got date of acquisition or depreciation and cost of acquisition, COA and DOA or depreciation. Of course, Mr. Kapasi will be taking us through that. And when I spoke about the interplay between the old law and the new law, we all know that the question of reassessment, 147 and 148, is an area which has thrown up so much of litigation, particularly after the judgment in Ashish Agarwal's case. So there is, Mr. Kapasi has got an entire section of his presentation to deal with the reassessment, the old provision, a comparison of the old provision and the new provision, and we look forward to that. I will just wind up in a minute now and hand you over to the moderator. I happened to watch the recording of a summit where the Honorable Finance Minister was asked, what is the next big development in the tax scenario going to be? And in that context, she makes a reference to the new Income Tax Act. And she says that the unfortunate phrase, I'm quoting her, the unfortunate phrase tax terrorism is now a thing of the past. Because what the new act ushers in is an arena of certainty, of clarity, and of ease of administration, which is ultimately going to benefit the taxpayer. We are all aware of the faceless assessments, the litigation that faceless assessments have thrown up, and we now hope that going forward, there would be clarity in respect of how these faceless assessments are going to be conducted. And that is going to inure both to the benefit of the taxpayer as well as all stakeholders, in fact, in tax administration. Incidentally, she said that the next big development is going to be a revamp in the Customs Act. And so I think perhaps one of the earlier speakers in the morning session spoke about the National Tax Convention in 2026. Perhaps one of the sessions that you will have there will be to do with the revamping of the Customs Act, because that's the announcement that you can look forward to in the upcoming budget. I'll stop with that. The Income Tax Department has a website, and in that website, they refer to Raghuvamsha and King Dilipa, where he says that the extraction of tax from a subject has to be seamless, like how a bee sucks honey from a flower. Well, whether the implementation, the extraction of tax under the new regime, how it is going to be, is something that we have all got to prepare ourselves for, to arm ourselves for. And that is why we have the speakers now. I would hand over to Mr. Shivaram, Dr. Shivaram, learned senior advocate, to take us forward, and I look forward to his presentation and the presentation of Mr. Kapasi as well. Any comments that I have, I will make towards the close of the session. Thank you very much.
May I request our moderator, Dr. K. Shivaram, to please take over the dais.
गुड मॉर्निंग टू एवरीबडी पे नमस्कारम कन्नड़ में नमस्कार बोलता है हाई फाई करेक्टली ओके इनफैक्ट दी माय डियर फ्रेंड पदम चिकिंचा टोल्ड मी आई आस्क्ड हिम व्हाट इज माय रोल एज ए मॉडरेटर he said Pradeep will present the paper, leadership will give the final comments, you have to just speak about minimum 5 maximum 10. So I cannot speak on the subject, I cannot give any comment on that, but I thought, speaking something which possibly, that our comparers morning introduced the Pradeep Kapasi and our leadership. One or two possibility not coming in your website about Pradeep or leadership. But let me share with all of you today. Honorable Justice Leadership, and of course, Samir Jani, I think President must be here. Joshi Saab is there. In fact, I thought giving an opportunity for me to stand before you. So I'm really thankful to all of you, including the office bearers. Leadership, one point I thought of sharing with you. Those who see the last corner, they put some photograph. There you will find in the 2002, our leadership, then as a member of AFTP, presented the paper on entertainment industry. And Lordship can also go and see that they have put it over there. So that shows that from 2002, that was the convention where I took over as president. Leadership presented the paper on that, the entertainment industry. And there, of course, she was there, chairperson of South Zone, and today we are honored, leadership will be there, is concerned. But one point which I thought sharing with the participant over here, when Justice Sriram, K.R. Sriram, became Chief Justice of Madras High Court, we met him for congratulating him, wishing him all the best. Then he told me, Mr. Shivaram, if I get an opportunity to sit on the tax bench, I would like to sit with the Justice Dr. Anita Somna. Lordship told, he regularly reads her judgment, and he holds high regard and hearing, and then he said, what I feel, that is the greatest moment, proud moment for all of us, because the Chief Justice of the High Court is telling that I want to sit with the leadership. We feel that very proud that we are associated with her, and it is a great honor for us. So that is the. Now, before I conclude, let me 3-4 points which I thought sharing with you. Now today we are having the Bangalore conference, and today we elected our learned friend as the president-elect. Let me share with you from Bangalore, the two stalwarts, F.R. Singh, Padamchand Kincha. I think they are busy with some other program, but I want to refer their name in absentia. They served the AFTP as a executive members from 1997 to 2011. That's long distance. And let me share with you those from Kolkata. You know, Sukumar Bhattacharya was our president, and he used to affectionately say, when Mr. Singhvi and Mr. Kincha speak at the conference, it is like a two-pan express. He says that fast, powerful, and full of knowledge. And our past president, P.C. Joshi Sahab, N.M. Ranka Sahab, and V. Ramachandran often used to refer them as the gems of our southern zone. And today, this is an opportunity for all of us to recognize their service. But when he had that opportunity, the president should be given southern zone. We all requested that either Padam or Singhvi should take up. But both of them said that no, we don't want any responsibility. We want to be an academician only. That shows that even today also in the federation, we are a good number of people. They are not after the post, they are not after they want only. With this, on 50th occasion, I thought of show my gratitude to the both stalwarts as I am standing before you, and we have to, in fact, it's a great opportunity, and we must recognize them as their request is concerned. Now you know that Pradeep Kapasi, the organizers have referred his biodata, but one thing I thought of sharing with you, a good friend of mine, you will not find in your note or there. Pradeep will admit, I think, right? Yes. But one thing let me share with you, Pradeep Kapasi writing on the controversies in the BCA journal for more than 30 years. So these controversies, what is selected. So with this experience of the more 30 years of experience writing in the BCA journal, those who are well conversant reading BCA journal will see every month he write on controversies, recent controversies. So that gives us how in-depth he has discussed with this, and he has selected about, I think, seven important issues, and ultimately Pradeep will present on that. Only one issue, what I thought of just sharing with you, the reassessment what he is going to present. But what I find, last about, I think, 6 to 7 years, 80% litigation across the country, it is only on reassessment. Lordship also must have dealt with the number of the judgment only on the reassessment. Then that 20% you will find 50C and 56. That is what one of the subject is going to discuss. And remaining is only very negligible, like penalty and other thing. And one other point which is going to discuss with you, that as regard that new provisions also is going to, what will impact on that. On reassessment, one can read our publication of the AFTP, which is written by Shashi Bekal and edited by Tushar Emani. It is available for the sale. It is worth reading, and it will give the lot of interesting for the readers are concerned. Finally, what Mr. Singhvi told, there are certain students, the audience. Only one thought I thought sharing with the students, and I could also see some young professionals sitting over here. I thought of sharing only 2 points with them. First of all, really if you want to master over the income tax law, read the ITRs from 1 to 100. That will be give the complete, that in-depth knowledge on the basic concept. Kangipal Kawala, 8th edition. Then for update commentary, you read Sampath Iyengar's, Kicham Chanda and Chaitanya as updated is. So if you concentrate, possibly I think you will be able to master or direct taxation is concerned. What we'll do is that with this, I will hand over Pradeep within the short term I have completed, because Pradeep requires at least 1 hour for the presentation, And what we intend to do is, after presentation, we desire to have question answers. Normally, any seminar without question answer, that will not be complete. So question answer, for this reason, some of you have a lot of queries on that. As far as possible, 15 minutes, Pradeep, we will give 15 minutes we will give for the question answers, and with that, I think thereafter we will end it with the chairperson's final view on that. With it, thank you very much for giving me an opportunity. Thank you once again. Thank you.
Thank you so much, sir. May I now request our speaker, CA Pradeep Kapasi, to please address the gathering.
Honorable Judge, Dr. Sumant, my very dear friend K. Shivram, my seniors, ladies and gentlemen, I am indeed pleased to be here to present some of the thoughts in relation to some of the not controversial issues but contemporary issues, which I would present before you. We have selected about 7 issues, out of which the 4 are ones in respect of which we will straight away jump to the discussion on the important issues which are arising out of that. In respect of the 3, I perhaps feel that I'll have to introduce you to the scheme before I take you up to the issues which there are. But before I say that, I'm honored to be here to present my views in the chairmanship or the chairpersonship of Dr. Sumant and also in front of Dr. Shivram. Thank you so much. We have been told that yes, we have about 1 hour. That should be good, and we will have some time for questions and answers also. The synopsis of what we are going to discuss is the transition provisions. At the judge told us that yes, that we are now about to transit from the Income Tax Act of 1961, which we all of us have been practiced since the time we started our practice. Maybe Mr. Joshi was the one who must have practiced even 1922 Act. Yeah, right. But other than that, most of us have practiced 61 Act. Very shortly, with 1st April 2026, we would get into a new concept, which is tax year 26-27, which would be way different from the assessment year. So for once, we will have assessment year 26-27, and we would also have the tax year 26-27. So there is a very finer distinction, subtle distinction between these 2 assessment years. For assessment year 26-27, law of 61 would apply, and for tax year 26-27, the law of 25 would apply. You may permit me to refer to the new law as 25 law and the old law as 61 law. It will make life easier. So the short question which we'll be understanding today is that how the transition would take place from the old law to the new law. And this is what we will have to keep in mind, because there are very subtle and important provisions which will have to be kept in mind. That this is for the first time the law has taken, the Parliament has taken upon itself to address the issues which will arise on account of the... This is not to say that 1961 Act or 1922 Act did not have such provisions, but they were very limited. As we will unfold, you will see that there are new provisions which have been introduced for the first time. While, I had some reservations, the original assignment was only about transition provisions, and I said that, this might on an outside would require not more than 20 minutes to discuss. So I said that let me expand the scope, and with the permission of the organizers, they suggested that why don't we travel to reassessment and reopening. And to that, my response was that even if one is given 20 hours, the story on reassessment would not end. As Shivram told you rightly, that 80% of litigation is all surrounded by reassessment. He did not tell you something that the rest of the 20%, the major part of it is consumed by the transfer pricing litigations. And of course, we have 50C and 56-10. So we have to also touch upon 3 important changes which have been introduced by the Charitable Trust Act practice. So I'll introduce you only to the 3 issues and what are the issues arising out of that. Then there is one old issue. Because of my ignorance, I have till date, since last 10 years, I have not been able to resolve that. So I'll present it before you, 50C versus 54 and 54F, and perhaps come to some kind of a collective decision which would help us to go further. Presumptive taxation, Shivram specifically told me that we need to see that, that we deal with issues, which are not only corporate taxation issues, but issues which arise in day-to-day practice. And as one would see, that large number of cases are governed by the presumptive taxation as far as the business, and even I see large number of professionals also have to follow necessarily the presumptive taxation income. So there are 2 issues which have been identified, which I once again believe have remained unresolved and are required to be understood. They are not regular, mandatory, mundane issues, but things which are little out of the way. So please pay attention. And the last is about the simple part, which is that the provisions of deeming fiction in 56-10 provide for an innovative substitution of the cost of acquisition and the date of acquisition. So we shall touch upon that. I try to do so. I'll try to see that, that all this is addressed within 60 minutes. You may pardon me at some point of time, if you find me to be accelerating or speeding up some of the, basic things, then you may pardon me for that. The first, we will deal with transitional provisions. There are several transitional provisions which have come up. The first one which we will take is to understand that, how the law will transit to the new law. And this is something very important, so we will deal with it. The first direction which has been given in respect of the new law is that all those orders and operations, that is acts, which have taken place under the 1961 Act, they will remain saved. They will not be disturbed. And therefore, if there is an order which is passed, it would not be possible to get into reassessment under the new law. So we will keep that in mind, that orders and acts, that is operations, are saved. The second is, if you have been conferred with the rights, privileges, or you have contracted obligations or the liabilities under the 1961 Act, they would also continue to be with you. They will stick to you, and anything to be dealt with in respect of those concluded provisions, will have to be dealt with only under the 1961 Act and not under the new prescription of 25 Act. The pending proceedings, by pending what I mean is proceedings which have been initiated up to 31st March 2026, they will continue to be governed. They will continue to be governed by the provisions of 61 Act. So therefore, as the judgeship rightly stated, that yes, that before we unlearn 1961 Act, it will be too long a time, because as I see that all appeals, applications and the revisions would continue to be governed by the 1961 Act. And importantly, even the search cases will be governed by them. So therefore, to unlearn 61 Act altogether may not be possible, and therefore all of us need to gear up to learn, to keep learning about 1961 Act, because it will keep on unfolding and will keep on surprising you with new aspects of 61 Act, which either may not have been settled, and at the same time we will also have to practice the 1925 Act. So repeating this is that new proceedings, the old pending proceedings will continue to be governed by that. Besides that, and this is very important, any new proceedings which will take place on or after 1st April 2026, but if they pertain to assessment year 26-27, if they pertain to assessment year 26-27, for which all of us would file return somewhere from 31st July onwards, even in respect of those, any issues arising out of that would be entirely dealt with by the old prescription, that is 1961 Act. So therefore, while filing the return of income, we will have to be clear about the provisions applicable. But even thereafter, while making assessments, appeals, and references, we will have to be careful about this. So as long as any assessment proceedings are up to 26-27, be that they are initiated today or year before or year after or on or after 1st April 26-27, this is an important departure which we are making in respect of repeals and savings, which is part of the law. Then even penalty proceedings for assessment year 26-27 would continue up to assessment year 26-27 will be governed by the old law. So if you were to receive any notice in the year 2030, if you were to receive any notice under 2030 in respect of any of the 40 penal provisions, they would continue to be under the old law and not under the new law. The time frame, the limitations, everything would be governed by the old provisions. Keep that in mind. If there are any proceedings which are presently pending, or even thereafter it would come up, but it would pertain to assessment year 26-27 or earlier years, and those appeals, those before the authorities, revisions, everything, even rectification, would be governed by the old law. So this in loose sense, they are known as provisions for saving the application of 1961. And the whole wisdom behind that is to ensure the continuity of the present proceedings, present law for deciding and executing the assessments thereafter. Last is, and this is also very important, is if you have made any election, and for this election what I mean is, if you have decided to be governed by the new regiment of taxation, then in that case, that election which is made under 1961 Act will continue and will transgress to 2025 Act also, meaning thereby that you will not be required to once again elect and declare that, sir, please grant me and govern me by the new regiment of taxation. And there could be several other such provisions. I have just shared with you one such. So this is, ladies and gentlemen, this is about savings. And now what are the important transition provisions? Let's understand them. The first is about interest on refund. Now it may so happen that for assessment year 25-26 or 26-27, you have filed a refund and you are entitled to a huge refund, which in turn is eligible for interest on refund. The law in short provides that for deciding the amount of interest payable to us or maybe leviable, payable by us also, in both situations, the law which would apply up to 31st March 2026 will be the law that of 1961, but thereafter the interest would be calculated for the period and for the rate which will be governed by the 1925 Act. The only issue which arises here of an importance is, in respect of this clarification, is that if an interest is already finalized, say today, as on 13th of December, an amount of interest is due to you, but for some reason that interest is not being paid to you for a long period, then in such case, the interest which is to be paid on an unpaid interest, there is no direct provision in the law, and for that you have to go to the courts to receive interest on interest. The law admits, the Supreme Court admits that you are, for deprivation of the interest, you should be compensated. But it is not an interest, it is a compensation. So for that, the issue that would arise would be that how would you determine? My simple answer to that would be that that interest on interest will continue to be a compensation and will be determined by the courts that what is the right amount that would be due to be payable for deprivation of the interest. carrying it forward, this is important, is that all of us have been conferred with the benefits, at times liberally, mainly under Section 47, mainly under Chapter 6A, and these are huge benefits which we derive under these provisions. Now it would so happen that these benefits which have been derived, which has been conferred on you, have been made conditional. You have assured the government of India that yes, I will religiously, diligently comply with the conditions, some of which have to be complied with hereafter under the new law also. Now in such case, the issue that arises that after implementation of the new law, if you stand to violate any of the provisions, then in such case, whether the new provisions will apply or whether the old provisions would apply. So here there is a difficulty, and the difficulty is like this, that the violation will be determined with reference to. Violation will be determined with reference to the old law, but taxation would happen with reference to the new law, because it would not permit them to reopen a case in the year, because the violation has taken place today, and you can't go back to the year in which the exemption or the relief was granted. And rightfully it has been thought that yes, that the compliance of condition would be examined with reference to the old law, but the taxation, the year of taxation, would be determined with reference to the new law. So this is an important take home which we will keep in mind. Recovery proceedings, yes, that while recovery amount which is unpaid would be determined under the old law, but the recovery thereof, if it is post 1st April, post 31st March, then it will be governed by the new. In effect, so therefore the relevant schedule, the relevant sections that would apply for enforcing the recovery would be under the new law, but the determination of the amount would be under the old law. Further, this is all these agreements like advance pricing agreements and any other agreements, transfer pricing agreements, which you have entered into with the government of India or any authorities, they will continue to be relevant, and they will not be withdrawn because the new act does not provide for such agreement. Similarly, if the approval has been granted to you, say for a backward area benefit for a period of 10 years, those approvals or any ministerial approval, they will continue to be operating, and you don't need a fresh license. You don't need to renovate them. No novatio would be required. This also is, according to me, good relief. What I singularly found relevant is that the orders, rules, directions, notifications, they have not to be revalidated. They have not to be reaffirmed by the government of India, and there could be thousands of such circulars. So what is good is that all those circulars will continue to be in force with an authority of law. They will continue to be saved and will grant the continuity which is most desired. Otherwise, the new circular which would come post 31st March might deal with the law very differently. So therefore, if circular is relating to a law of 61, they will continue to be. But what is important is they have not to be restated, not to be reaffirmed, not to be revalidated. Carrying further is that all applications, appeals, they will be determined, though from 1st April 2026, but with reference to by applying the law of 1961. Credit for taxes paid, and this is heartening, is that yes, that I would get credit for the taxes which I have paid. Say simple example is the MAT and the AMC. So in respect of this, what is unabsorbed credit that will continue to be granted to me under the new law. No separate orders would be required, but the change would be that it would be for the period for which the new law permits you to carry. They might extend it also, but this is an area which will remain to be it will be a subject matter of little further discussion. But presently the way the clause is provided, it provides that I will be entitled to take credit for the remaining period of the unabsorbed amount. This is wonderful. All losses are saved. all losses which have remained unabsorbed are saved, and these are the periods, these are the provisions under which these losses could remain. They will be allowed to be carried forward, and here the change is that it will be allowed to be carried forward for the period for which the license has been given under the respective provisions. The new law will have nothing to do with these losses. You will be able to carry it forward as much is permissible under the old law. This capital gains, so while the bill was introduced, there was a hope that even long-term capital loss which have remained unabsorbed, they will also be allowed to be set off at least for one assessment year, that is tax year 26-27. As it is seen is that the law finally as is enacted, this section 111 of the new law does not anymore permit you to set off the unabsorbed long-term capital loss. Having said that, other than that, all long-term or short-term capital losses which have remained unabsorbed will be absorbed within a permitted period under the new law. Same is with depreciation. Importantly, it has been made very clear that depreciation of which has remained unabsorbed will become part of the current year's depreciation under the new law. Now, this is very heartening. There are two things. One is to allow you to absorb the unabsorbed depreciation, and the other one is to treat this as a current year's depreciation, and this is something which impresses me, that it becomes part of the current year's depreciation. And therefore, once it becomes part of the current year's depreciation, what we need to take home is that it will thereafter be governed by the provisions of the new law and not the old law anymore. Accumulated losses under 72A, 72AB, all these will be carried forward under the new law and will be allowed to be absorbed for the old period, which is licensed. This is specifically made out that the legislature believes that 47A is the provision which is a special provisions for withdrawing the benefit. Now, there could be various conditional allowances which we have already spoken about, but 47 capital A has been singled out. It's a provision which says that, several of the specified reliefs which have been given under section 47, under different stipulations and enactments, if they are withdrawn, the violation of the condition would be examined under the old law, but its taxation would be governed by the new law. Its taxation would be, so head of income, the year of income, and the rate of tax would be determined under the new law. The only thing, violation would be determined under 47A. While, when we talk about it, it appears to be little simple, but when you would put this in a practice, you will realize for yourself that you are dealing simultaneously with two different laws, and both the laws will apply to the same situation. So how to reconcile that is something as professionals we will have to guide our clients dutifully. Like that, there are all unabsorbed capital expenditure of the section 35 kind. They will also be governed in the similar manner. Amortized allowance of 35ABB, 35D, DDE, 3619, all of them also would be governed by the similar principles which we will keep it in mind. Bad and doubtful debts, in order to ensure that, a provision which has already been allowed as a deduction under the 61 enactment is not once again claimed under the 25 law. Therefore, a special provision is made that if a deduction has been granted on the basis of a provision, so when it eventually becomes a bad, you will not get deduction if it was already granted. If it was not granted, I think you perhaps are welcome to claim the deduction. There is no specific provision, but I believe that should be the understanding of the law to make it more human. Now, this is important, that all schemes which are faceless schemes, be that in relation to penalty, be that in relation to assessments, or be that in relation to the filing of returns and all. All those faceless schemes, including for appeals, will continue to govern and will not have to be restated or reinstated in the 2025 Act. And this is, according to me, is a singular gesture which will have to keep in mind. This is little different. That all search and seizure actions under section 132 or 132A, requisitions which will take place, up to 31st March 2026, till the time they are finally rested by any of the courts, including Supreme Court, till such time, its assessment, block assessment, its appeals, its references, its revisions, everything would be, and special leave petitions also, everything would be governed by the 61 law and not the 2025 prescription. Having said that, we all are also governed by the General Clauses Act. And it is this General Clauses Act, it has its own stipulations for deciding what is saved and what is repealed. And this is something where the law does not on itself take upon the responsibility or the task to provide for repeals and savings. Then in such cases, the General Clauses Act would prevail and the courts will decide that in such circumstances, GCA will apply or not. Now, therefore, having said that, there are about 14 situations which we covered, there would still be another 1400 situations wherein you might go to the court and say that, look, this is not which is specifically saved, or it could have been repealed. And in such cases, what is decided by Section 6 of the General Clauses Act, is something which will come to our rescue. So it is another provision which I would advise you to really look into it. Because this transition is not going to be very simple. It will come with its own pains. Some of them may be very interesting also, and some of them could be professional opportunities also. Howsoever, in bigger cases, it will be very important to examine these transitional provisions, especially 536 of the 2025 Act and Section 6 of the General Clauses Act. With this, this is what, I may now be permitted to accelerate a little. This is synopsis of what we are going to discuss, or at least touch upon about the new scheme of, this scheme, friends, is introduced in 2021. If you see the 2025 Act, there is no material difference between the two schemes. So therefore, if we accept it to begin with, that there is no material difference, and if there is a difference, I'll identify so. But therefore, discussion which will take place today in respect of 61 Act will also apply with the same force in respect of the 2025 Act. Only the section numbers would be different and the placement may be little distorted. So this is what is the new scheme, which is from 147 in a short span of just about 4 years of its existence. The law has been amended in 22, in 23, and once again in 24. That simply shows that what kind of a stability which the finance minister is assuring us, in respect of 2025 Act. In fact, yesterday just I was glancing through the latest development, and there was some discussion that whether this year's finance bill, this year's budget would ever have a finance bill at all. Obviously, you would feel that if such a wonderful exercise has been carried out, a massive exercise of substituting the enactment for after 64 years, you perhaps would not need a finance bill of 2026 at all. But it's, the views of the professionals are very different. They believe that, the work is already begun. The government is not happy about what they have legislated in respect of 2025 Act, and I will therefore not be surprised. Maybe yes, it is their power and it is granted that they have a power to legislate. The point is that the stability which is being assured, the ease of legislation or ease of practice which is being assured. Income Tax Act is one such law, will never have a stability. That's my personal view. I'll be very happy. But, I'll also be true to myself that right from the time when I started practice, which was in 81, 82, till date, I am seeing that, more than 10,000 amendments have been made. Every year the law has been amended. One year you introduce a law, next year you change the law. Simple example is what? If you see that, we had search assessment under the regular provisions. Then you introduce block assessment. You did not like it. In less than a decade, you changed it to special assessment. You once again did not like it, and now you have reintroduced block assessment. So all this, we do not know how, and these are dangerous provisions. It's not very easy for the regular practitioner to master these, leave alone the practice of all these. So therefore, the point is coming back to this is, the new scheme, as I said, has been amended. What is important here is that under the new scheme, provisions of section 153, 153C are specifically made redundant in respect of search which has taken place on or before 31st March 2021. Important concepts that have been made irrelevant, and this is something we need to take notice of at least. Under the old scheme of reassessment, what was important was there was a need for an income that has escaped assessment. An income that has escaped assessment for which the AO had a reason to believe, for which the AO had recorded the reasons. So three very important legs of the scheme or an assessment to survive the test of law was that there must be escapement of income. The AO should have reason to believe that income has escaped in, and AO should have recorded the reasons. And the fourth leg was that the AO, as per the Supreme Court decision in GK and Drive Shaft, was required to give you an opportunity to object to the reasons, to serve the reasons and to object the reasons, and pass an interim order disposing of the objections. Now, all these four have been done away with. All these four have been done away with. There is a need which is limited to that he must be in possession of an information which is suggestive of escapement of income. Now, this could be way different than the reason to believe. Anything which is suggestive of escapement of income would now be considered to be. What is only predominantly required is that the AO must be in possession of some information. And that information also is defined. It's straitjacket formula that this is information, wherein it will be deemed that income has escaped assessment, and it will give him a license to proceed by issue of a notice under section 148A. So what are the new concepts? Fortunately, that many of us, fear this 148A. After a few years of practice, I have felt that it is a blessing in disguise. 148A is nothing but carrying out the Supreme Court mandate given in GK and Drive Shaft, wherein what court said is, you share the reasons. You share the reasons, allow him to object, and dispose of the objections, and thereafter, you proceed with reassessment. The important difference which is being made is that all this has to be done even before the AO is given a handle to rotate by issue of a notice under section 148. So what is now required is that 148A notice should precede 148A notice, which is a new prescription. It should proceed, it should be issued. The AO must be in a position to share with you the information. He should invite your objections, which are not objections, but which are replies to show cause notice, and thereafter he needs to pass an order. He needs to pass an order. It is only when this process is carried out within a period of 3 years or 5 years, after within a period of 3 months, the AO is then authorized to issue a notice under section 148. And after he issues the notice under 148, he has to once again take a permission from the prescribed authority, that is specified authority. And thereafter, at the same time, he has to serve you with a copy of the order which is passed under 148A3, which was earlier 148A small d, and also share with you information. This is nothing but stating and confirming by the legislature all that law which has been developed before the courts, including the Delhi High Court decision in the case of Subulab developers or something, and the GK and drive shaft. So therefore, I welcome 148A provisions. The only thing is the way it is being practiced is highly, highly unfair. The information is not shared, the notice under 148A is issued, the submissions which are made before the AO are not considered, very short time for giving submissions is given. So all this is something, so because of that, Shivram would agree with me that several reopening cases are the cases wherein the writ petition cases, wherein the courts are left with no option but to refer it back to the assessing officer. And in the process, it consumes a time which is something which could have been saved a lot. So now, the notice which will be issued under section 148 would be issued within a period of 3 years and 3 months. This is a new prescription. We know about 5 years, 10 years, 6 years, 4 years. But this is a new prescription. So if the escapement of income which is believed to be there, and if the period of 3 years have not passed, by the end of the assessment tax year, this also is saving a lot of time, because now this period will have to be examined with reference to the end of the tax year. When it was with reference to end of the assessment year, the assessing officer was getting not 6 years but 7 years, not 4 years but 5 years. Now it's clearly provided that it will be with reference to the end of the tax year, and 3 months and 3 years. That is the time. So 148A time is 3 years. After 148A is done, the notice could be served within another 3 months. So therefore, you will have 39 months from the end of the tax year. So this is something which will have to be memorized, but otherwise to me it's very simple. And I believe that it is most welcome also. So 3 months are extended, that is true. The only thing, which is disturbing me is that, and that is my personal view, is that reopening now would become a new normal. Something which was an exception under the old law up to 2021. That reopening was a rare case scenario. It was not, notice under section 148 were not liberally issued. And in some of the office, 148 hardly used to come of the professionals. They used to take pride in saying that hamare office mein 148 aata hi nahi hai. Now there could be some kind of a confidence behind ensuring that. But that is how it was going about. Now what's happening is every second notice is a 148A notice. So therefore it has achieved a new normality, and this is something we will have to understand. Like what, see, we used to understand 143, like on the back of our hands. Now we'll also have to understand 148A, 148 right up to 153 about this. I have summarized many of the things, so you may permit me to proceed further. What is information? Important thing is that there must be, AO should be in receipt of information, and this should be in possession of the AO. The one such information is that something which is flagged on a computer need not necessarily be the computer of the AO, need not necessarily be the system of the AO, but a general system on which if there is a flag which has been delivered by, which has been hosted by the risk management system of the CBDT, then in such case it becomes an information if it is relating to the assessee of the client. The assessee of the case, this is one handle which he will be in a position to leverage. Second is audit objection. When the law was enacted, the amendments were enacted, It was the final audit objection received from the central board auditor, the main chief auditor, that was alone gave a license to the AO to issue a notice. Now even any audit objection received by the AO is a tool in his hands to treat this as an information, so we'll keep that in mind. Any information which is received under the taxpayers information treaties with several countries under section 90 or 19A, that could also be an information for him to proceed or at least issue 148A. Now, the government of India today, if you would see through its arm, Central Board of Direct Taxes, is collecting endless information from the registrar of the assurances, from various other sources under section 133, 133.6, 133 and so many. Now, and 135 also. All this information, whenever it is passed on to AO under section 135A, then in such case, not only this will act as an information in the hands of the AO, but it will give him a license to bypass the provisions of section 148A. This is very important. You will no more receive 148A, and 80% of the cases are 135A cases. He says that I am in possession of information, which is received from the Central Board of Direct Taxes under 135A. So fine, period, you can't do anything. Then in such case, 148A, the entire process of conducting inquiry by AO, issuing show cause notice, receiving reply, and passing an order with the authority of the specified authority sanction, all this is bypassed. What you will get is, you will get a 148 notice. So the first thing which you need to check is that whether he is really in possession of 135A or not. And this is something, it could be troublesome even for the AO. But besides that, what is important is that the whole process, which was a guarantee to the Supreme Court decision, has been bypassed by simply 135A. I'll not be surprised if more and more such information which permits AO to bypass 148A, because 148A is a pain in the neck of the assessing officer. They don't like this 148A at all. They simply want to accuse you of having escaped the income. So keep that in mind. But what is good is that when he issues 148, in pursuance of a 135A notice, for issuing the notice itself, for normal 148 notice, he doesn't need an authority, doesn't need a sanction. But for 148 notice, without process of 148A, he will be required to be obtaining the sanction from the specified authority. This is something I have discussed with you. This also I have discussed with you. Yeah, order with approval that we have discussed. Time limit is, as I said, that 3 months, 3 years and 3 months. For 148, 3 years for this. Now here, two important things which we need to keep in mind. 149 is one of the most important provisions in this scheme of reassessment. 148, 148A, 147 is pre-reassessment stage. It is precautionary stage, while 149 is a stage which decides that what is the time within which the AO gets a power to do something, to accuse, to allege something. So what is now provided under the new prescription is that if AO is in possession of an information that that information is suggestive of escapement of income, then within 3 years, he is required to issue a notice under 148 and complete his inquiry within a period of 3 years. And he gets additional 3 months for issue of notice under section 148. This is decided by new provision of section 149, which is totally overhauled and substituted. So we will keep this in mind. Second is, if the income which has escaped, which is suggestive of escapement, happens to be 50 lakhs, happens to be 50 lakhs or more, and AO is in possession of books of account, document, or not just information, some evidence. AO is in possession of some documents, some evidence, other than simple information, and books of account. Of whom? Of the assessee, I would like to believe. Later on, see, the ladyship will decide which is the correct position. Whether it is third-party information or books of account would be correct or not. But right now, the way I read the law is it should be pertaining to me. Okay. And if he has some evidence pertaining to me and my documents, and those documents pertain to the relevant assessment year for which the notice under 148 is going to be issued, then in such case, he will be in a position to issue a notice within a period of 5 years, not 10 years. See, 2024, the period was up to 10 years. Now it's been reduced to 5 years and 3 months. So this is also one of the most important amendment. As compared to that, if it's relating to some foreign asset or a foreign income, the Black Money Act empowers the investigation authorities and the other authorities to issue a notice within a period of 16 years. But right now for us, today's discussion, 5 years and 3 months, that's sufficient. We'll keep that in mind. The earlier, it was always, these provisions of reassessment were approved by the courts on the understanding that the highest of the authorities were authorized to permit or sanction the reopening, which is now not so far. Even a JC or an additional commissioner is authorized to sanction this, and which I believe is something which the profession should also object. Whether the JC himself would have enough understanding of the law, I very much doubt. But that apart, that is the position. If all of you who are in the day-to-day practice would understand that when such reassessment are being made, the sanctioning authorities themselves conduct the reassessment. Now this is a serious violation of the promise of the law, assurance of the law, but this is how it is. Now faceless assessment 151A, which we need to understand here is that the government is required to notify, and there it has notified a scheme stating that all reassessment proceedings, including reopening proceedings, will be conducted in a faceless manner. Now when they are being conducted in a faceless manner, this scheme has to be tabled before both the houses of the parliament, and thereafter they will be in a position to proceed further. What is important here is that there is a serious litigation which has developed here, which while dealing with some other issues surrounding reassessment in reopening, so I have selected only 4 issues because it is impossible to deal with all issues, something which I believed that I am ignorant about it, which I do not have a specific answer. So I am presenting it before you. One is the change of opinion. The Supreme Court famously approved the Delhi High Court's decision in the case of Kelvinator, stating that if a reopening has happened on account of a change of opinion of the assessing officer, that reopening is not valid in law. It's bad in law, and the proceedings are nothing but to be quashed. So this is what the understanding for last 60 years, wonderful understanding. And 50 out of 100 cases were the cases of change of opinion. One assessing officer one day felt that this is not taxable. After a few years, the same assessing officer felt, why should it not be taxed? After a few years, the other new incumbent felt that it should be taxed. And sometimes even the revision takes place. So it is here that, that the law, old law was examined and was concluded, and that became the law of the land. But a serious doubt has already arisen that whether that position prevails under the new law, because the new law is not whispering about it. If you see the powers of assessing officer, they are too wide. And even if he is in 2 mines or 3 mines, perhaps, it may not prohibit him. Fortunately, the courts have come to our rescue under the new scheme or new prescription of reassessment, reopening, that in wherein the courts have said, if a view has already been taken on the basis of the records available before him, which have been examined by the AO, then in that case, he cannot have a change of opinion, even if he is in possession of information, even if he is possession of audit objection. The point here is that though there is no reason to believe any more required, the point here is that some information which is suggestive of escapement has already been examined. The mind has been applied. 148A kind of an order has been made, and that cannot be substituted. I believe that if this is not allowed to be disturbed by the Supreme Court, or the law is not amended, which should not be, because it would be a retrograde step, something which is allowed, the law finally hangs on. The revenue laws hang on what? An understanding and the principle that tax issues should be allowed to be settled, and assessment should be settled qua a particular assessee, and it cannot endlessly be reopened or revised. So this, I believe, is a wonderful thing. I have brought it to your notice. It's a recent controversy under the new law. Second is information and reason to believe. We have understood that there is no more reason to believe. Now the quality of information, should it be equivalent to that which provides the assessing officer with a reason to believe? And once again, the courts are with us. I am expediting a little, is accelerating a little, is the courts are of a clear view that an information by itself is not sufficient. The AO should inquire into the information. AO should apply his mind that this is suggestive of escapement of income. And these are the very words which the new law is used. Suggestive of encasement. So what do you give meaning to? So all these two decisions, hang on to this. Hang on to this. The only exception which I doubt is that there are cases of a deemed information. In cases of a deemed information, 148A is totally bypassed. And in such cases, whether the courts will help us in holding that even in such cases, before issue of 148, it was necessary for the assessing officer to inquire and examine and looked into the quality of information. I'll keep my fingers crossed, but it is something, in the next decade will be a big debate. Additional claim of reopening. This is a Karnataka High Court decision. Under the old law, Sun Engineering Supreme Court decided that reopening and reassessment is for the benefit of the Sarkar, that is the government of India. And you cannot use this as a handle for the purposes of making additional claims. And this was the law which was understood, but with an exception that when you are offering an additional income, and if there is a deduction associated or a relief associated with that additional income, you are allowed to do that. That also was a sole singular decision of the Karnataka High Court. Now what has happened is, under the new law also, this is the decision of the Karnataka State Cooperative Apex Society, Apex Bank, wherein the courts have taken a view that under the new scheme also, that position continues. So to my mind, it is a heartening thing to read the old law into the new law for conferring the benefits on the taxpayers, especially in reopening. Now, reassessment beyond reasons we have discussed. What I mean here is that once an AO has an entry to reopen your case for taxing you in respect of one particular source of income, once he assumes the power to enter into your house, can he therefore also cover some other income also or not? There is a specific explanation in relation to that, which is authorizing the assessing officer to do so, subject to a caveat that the reason for which the case was reopened, in respect of that also some addition should be made. If that reason is found to be absent altogether, then to tax a person in respect of a fresh source of income is debatable, and this laid down is correctly laid down. This is the last controversy on this faceless assessment. अब presently क्या हो रहा है करके, that the jurisdictional assessing officer, the one who has the jurisdiction over you under 119 onwards to 130, is the person who receives the information. He is the person who issues 148A. He is the person who conducts the proceedings under 148A and passes also the order. But 148 is issued by the faceless assessing officer. So this is story about FAO versus JAO. The courts are now very clearly holding, subject to dissenting decisions of the Delhi High Court, that in such cases where dual jurisdiction is being assumed, such proceedings are bad in law. They can't survive and they can't be substituted, they cannot be reinstated, they cannot be set aside also. Sorry? Yeah, fair. So the point which I am trying to make out is that always look into the proceedings, किसने पहला notice issue किया है and किसने finally conclude किया है. So if there are two phases, then be sure that these assessments can be challenged. Charitable trust, three amendments I am bringing to your notice, which are 2025 amendments, and I believe they are important amendments. Otherwise, the whole scheme has been revamped right from 21 to 24. But 24 were the major amendments. I don't wish to deal with them, neither I would have time for that. But three important amendments I am introducing to you, that presently all of us who are in practice of charitable trust are aware that a charitable trust has to be specially registered under 12A or 12AA or 12AB, and which is now provided from 21 onwards, that we all were required to, even if we were registered, to file a fresh application in 10AB or something and seek up registration for a period of 10 years. So every year you don't need to do so. It remains undisturbed and the AO or the CIT also will not disturb it. This is what is the position about this. So this was for 5 years. Now by this amendment it is extended to 10 years. So those existing trusts who had applied in 2021 for extension of time of 5 years, now that time is further extended without any fresh application to a period of 10 years. Need to notice here is that this for the new trusts or new trust deemed to have been dissolved, all licenses will be deemed to have been dissolved, all licenses will be deemed to have been cancelled, and all assets which the trust owns is deemed to have been distributed. And the difference between the actual cost and the market value will be subjected to tax at the maximum marginal rate. Even 45(4) does not do so. Okay, at the maximum marginal rate in the year in which you have violated the law under section 115D, this was a serious thing. Yes. Please close, but do I have some time? 5 minutes. Okay, very well, very well. In fact, I was waiting for it for long. Right, yeah. No, I'm serious about it. I'll complete at least the important part is that this is, and it will not take more than 5 minutes, is that it is here that now it will be no more a defect in the application will no more be considered as a violation. So therefore, 115 TD will not apply. The last is also a very important provision is, so far, if you have contributed 50,000 or more by way of donation to the charitable trust, then you become an important person. You become a special contributor, substantial contributor. Now this has been increased to 1 lakh of rupees. Secondly, it is coupled with another provision, says that overall you should not have contributed more than 10 10 lakhs of rupees. When these twin conditions are satisfied, it is only that you will be considered as a substantial contributor. So all those disclosures and other requirements, audit requirement, accounts requirement, receipt maintenance, all these will end in respect of substantial contributor. The two following amendments are also good, is that such a person, his relatives, will not be any more considered to be special contributors. And secondly, the related concerns also will not be considered to be special contributors. So therefore, it will not sting them. Otherwise, even if my relative had contributed 55,000, then it applied to me. So that is what is something which will not apply. There is saving from HUF for disclosure, and the person, such persons will however continue to be an interested person, and the auditor will have to continue to disclose in relation to or examine the things. There is a nagging controversy, and pay please a little attention, is here that a person who has sold immobile property, and for that capital gain which arises, in respect of that he is entitled to benefit of reinvestment, either under 54 or 54 EC or 54F. आप सबको में से ज़्यादा पता है. The short question which we have to examine here is that when 50C applies, you have sold a property for an agreed value of 1 crore and 30 lakhs of rupees, and the stamp duty authorities have valued it for 2 crore and 60 lakhs of rupees. The short question which we are examining here is that for the purposes of reinvestment, should I reinvest 1.30 crore or 2.60 crores? And related question is that वो बाकी का 1.30 crore लाऊं कहाँ से आएगा? My capital gain is 1.30 crores. So these are the two issues which have been examined time and again. So is it sufficient that I reinvest 1.30 crores? There could also be cases that I have out of 1.30 crores, that is the net consideration, 54F we are talking about, I have reinvested 1 crore only. Now in such case there is a third controversy arises, that if I have partly reinvested, then whether the whole of the 54F is exempt or not. So these are open issues which have been examined by this decision, including by the Karnataka High Court. The three wonderful propositions which are being laid out, and I am neutral on it, I don't take sides, especially of this is concerned. The Jaipur Tribunal has clearly stated that if net consideration actually received is reinvested, if fully reinvested in purchasing the house property, then 50C has no application at all. That's one. In Raj Babbar's case, Mumbai Tribunal stated that what is the problem? उसने 1.3 crore नहीं, उसने 2.60 crore reinvest कर दिया है, because he had extended his bungalow. So he in any case was to spend that. So tribunal said that don't come to us. Even assuming that you are right, but we hold you to be not right, because he has invested more than 260 crores, 2.60 crores. Now, Karnataka, Bangalore Tribunal stated that you need to first compute your capital gains by applying 50C. And thereafter, whatever is the quantum that is required to be reinvested is something which would be determined. This matter traveled to the Karnataka High Court, and High Court made a material difference, but it confirmed the AO's finding that effect of section 50C has to be given first. Effect of section 50C has to be given first before you apply the provisions of section 54F. The only food for thought which I can share with you is that kindly look into the fact that all this taxation of capital gains happen by virtue of a charging provision, and charging provision is section 45. 45 starts with this, that any profits and gains on transfer of a capital asset subject to host of provisions including 54 and 54F. There are about 8 provisions, would be taxed in the prescribed manner in accordance with provisions of section 48, right, in the year of transfer. This is what it is. Now, if the law of mandate of 45 requires me to give effect to 54F, then am I not right in first giving 54F? Why should I give primacy to 50C before I travel to? Even 54F is of special provisions, and so is 50C also. So therefore, in such circumstances, when what is heartening is 45, that is charging provision itself says that please give effect to 54. Please give effect to 54. The last contribution on this could be that my personal view is, I may be wrong also, that 54F, you have a stronger case. Whatever is the net consideration that is required to be reinvested. If you have reinvested the entire net consideration, you are standing on a very strong leg. Because under 54F, computation of capital gain is not required at all. As against that, what is required to be reinvested under 54 is the amount of capital gain. What is exempt under 54 is the amount of capital gains. अब ये capital gain कहाँ से ढूंढूं? For that I will have to give effect to 50C. This is one understanding of the law. But counter to that is that apply 45 first, apply 54F first before you even think of 50C. And that is what is the ace builder in Supreme Court. While applying provisions of section 50, it stated that if it is otherwise eligible for exemption, then that should be granted. But different view is possible. Presumptive taxation's two important issues. Just one, when additions are being made under 68 to 69D, you are aware that it would be taxed at the maximum marginal rate under 115 BBE. Now, in such circumstances, can you take the shelter that I am being governed by presumptive taxation? The answer is, if it is taxed as a business income, if the 68 to 69D transactions pertain to my business activities, if I have taken cash credits in the course of my business, employed the cash credit for purpose of my business, these are the decisions which hold that yes, in such cases, presumptive taxation income which is determined, that 8% or 50% or 7,200, that will be the one on which I have to pay tax. There is a dissenting decision of Allahabad High Court. Those of you who would like to go deep into it, please look into that. What I understand is, for the purposes of section 40A, 40A1A, 43B, section 37, surely income cannot be jacked up on account of additions or disallowances, for the reason that it is all about business income. And presumptive taxation is all about taxation of business income. I believe that there should not be. This is another difficulty which will now be so more pronounced under the presumptive taxation, under the taxation law of 2025. And what is that? The short issue here is that whether I have an income of 1 crore of rupees and I am declaring an income of 8 lakhs of rupees, am I required to declare the higher income of 1 crore or not? Because my turnover deals with a turnover which gets 8% as income. It's less than 10 crores, 3 crores or whatever is the amount. Then in such case, the issue is that the difference of 92 lakhs rupees I am required to disclose or not. The way the sections, there are 3 sections, 44AD, ADA and AE. All of them employ very different languages. You know, some say whichever is higher. The other two do not whisper about it. But now the new prescription provides for the tax year 26-27 that actual income has to be offered or the presumed income, whichever is higher. Now with this, you know, you may pardon me with 270A. It might take 10 or 15 minutes, but it's everything what I wanted to say. I have dutifully placed it in the form of bullets, and 49.4 is a wonderful provisions, and the limited discussion which one is trying to examine was that whether 49.1 would prevail over 49.4 or not. In a case where you are in receipt of a gift, the 49.1 provides that the cost of previous owner is to be adopted. 49.4 provides that the cost of the amount which is added as an additional income under deeming fiction under 56.210 is to be considered as the cost. So it is here that which one would prevail over that. Having said that, I am extremely thankful to my chairperson and the moderator, for having given me enough time, and to all of you for a patient hearing. Thank you so much. Thank you.
Thank you so much, sir. If tax was a maze, you just gave us Google Maps. Sometimes Google Maps also delays a bit. But this was a session that turned complexities into clarity. Thank you for this intellectual masterpiece. Ladies and gentlemen, first technical session we had Chairman Honorable Dr. Justice Anita Sumant, Moderator Senior Advocate Dr. K. Shivram, and Speaker CA Pradeep Kapasi. Ladies and gentlemen, please give them a huge round of applause.
With that, ladies and gentlemen, with our insightful session, we now move on to a well-deserved pause in our day. They say a mind full of knowledge must also meet a plate full of nourishment. And after such a deep tax discussion, even Section 14A is feeling hungry. So with great pressure, we announce a lunch break from now, which...
One minute. Only thing is, that we will dispense with the question answer. Okay, it's not possible to have it because, Pradeep has raised late. I know there are so many questions are there. What we can do is, question we can ask to him at lunch time, okay? Because, lunch is getting late. What we can do is only one thing, as Pradeep has about 7 issues, for Venkatramani interested to have the various lecture course, I think each session, each topic you have suggested require at least 2 hours. We are very sorry, Pradeep, you could not complete all this one. But the whole thing is, I thought, please bear with us, at least 5 minutes. Our ladyship I was watching her, so noting some important points on that. At least before you give vote of thanks, please give your ladyship at least 5 minutes to speak a concluding remark. Please, please. Because we will not get any opportunity to hear her, at least, ladyship, please come.
Sure, sir. Ladies and gentlemen, please give a huge round of applause for Honorable Dr. Justice Anita Sumant, Judge, Madras High Court.
I promise not to take more than just a couple of minutes, only because Dr. Shivram was kind enough to call me, even though the MCs felt that the session had come to a close. First of all, thank you very much, Mr. Kapasi, for a very comprehensive, very detailed session. And as Dr. Shivram said, any questions? I think it's a pity that all of us will not be able to hear the answers to the questions. But any questions that you have, I'm sure Mr. Kapasi will be happy to take over lunch. I'll just round it off. One thing that I found was, see, this physical copy of the Act that they had placed here, I do find that it is one of the thinnest income tax acts that we've had over the years. This yellow section is the comparison between the provisions in the 61 and the 25 Act. And then we've got a section of annexures at the end, the notes on clauses and all that. So what they say is that there has been a significant reduction in the number of provisions from 819 to 536, 47 chapters to 23 chapters, and the word count has also come down from 5.12 lakhs to 2.26 lakhs. Now how this is going to translate into practice is what we will have to see. Just one thing that occurred to me is that you're looking at an era of at least another 15 to 20 years when we'll be dealing with both the provisions of the 1961 Act and the 2025 Act. At least speaking for the Madras High Court, we have got matters on the tax bench which are now relating to perhaps early 2020s, early 2000s onwards. So about assessment years running for the last 2 decades are still the subject matter of litigation before the courts. So it would be too optimistic to think that overnight we've gone into a new era of taxation. But one thing we can be sure, that you have a parallel, you will have an overlap or a parallel system of the 61 and 25 Acts for about 15 to 20 years, and thereafter you can possibly slip seamlessly into the 2025 Act as it will stand at that point in time. Even today, we have got some legacy litigations relating to estate duty and gold control, which you know was, and wealth tax, which was abolished so many years ago. So it will be very hard to completely say goodbye to the 61 Act. But Mr. Kapasi mentioned in the course of his presentation one thing which was very heartening. Circulars, the double taxation avoidance agreements, they are all to continue. So one very interesting aspect will be when we deal with issues under the 61 Act and the 25 Act, how much are we to be informed by the interpretation of those provisions by the case law that have been rendered under the 1961 Act when we interpret the provisions under the 2025 Act. That would be very, very interesting. Exciting times ahead, and I don't think as professionals you could ask for anything better. Thank you very much.
Thank you so much, ma'am. Your leadership, we ask apologies for that. With that, now request all of you to please enjoy the meal arrangements prepared for you. We request all the delegates to return by 2:30 sharp, as the next session promises to be as enriching as your lunch. In true conference style, let's tax and then relax. A small announcement, all of your delegate kits are available in counter number 3 and 12. Request all the delegates out here to please collect your kits before you leave for lunch. Thank you so much, speakers, moderator and chairperson. We ask apologies. With that, now we break for lunch. Thank you for your gracious attention. The kit counters for the delegate kit, I request all the delegates to not hurry. The counters will be open for the entire day.